May I
Yes,
please,
yes.
my lord, I beg to mention item 26 and 27. It has become infectious.
Admission matter.
My lord, it is a transfer matter, my lord. It has got a flux of time
Okay.
become infectious.
Forest department, anybody is there? Okay. Okay. Sri G.I. Bolbhia, learned counsel for the petitioner, submits that by flux of time, the matter has become infructuous. Also heard, also heard Sri K.P. Pathak. No, Sri K.P. Pathak, learned standing counsel forest department is present along with the state council Sri R. Dhar. Para? Petition is accordingly dismissed as infructuous. Separate orders, huh? Okay.
My lord, another thing, my lord, there is a physically handicapped persons, my lord. I challenge there, my lord. I have not been given appointment, my lord. That may be listed, my lord, any day next week, my lord.
Motion matter.
No, my lord. Admission matter.
Admission.
Admission.
Matter of which year?
Matter of, my lord, 2023, my lord. Once it has been listed, after that it has not been listed.
Okay, Wednesday.
Well, next week, my lord.
Next Wednesday.
I beg to mention listing a motion matter on Monday.
Let me make, kindly this matter will be listed on next week, Lordship, for admission.
Matter, what is the subject
For
matter?
2020, Lordship.
20
Election
matter.
and appointment in a take a handy opening festival.
2020, okay, Wednesday next.
Lordship.
Lordship, item number
Monday. Monday.
item number 57 to 59, Lordship.
Yes.
In this matter, affidavit on behalf of AFDC is pending, Lordship. So I'm praying for some time.
You're filing today.
Not today, Lordship. I'm taking some
Yes,
time.
inform the other side.
Yes, I'm praying for
57 to 59.
59.
AFDC.
Yes.
Sri P. Nayak, standing counsel AFDC.
No. I'm assisting advocate.
Okay. P. Nayak, you're appearing as what?
Appearing on behalf of AFDC.
It's not standing. Okay. Learned P. Nayak, learned counsel appearing for the AFDC, submits that the affidavit in opposition would be filed shortly, and he prays for some time. Put the para list on a thoroughly. Sri N.J. Khatani, learned counsel for the petitioner. Applicant petitioner is present. Para list on 19th is okay.
Lordship.
19th. 19 August.
Please,
57, 58, and in two matters, Mr. Kumar is there. Mr. Nayak, Mr. Khatanier. Rest two matters, 57, 58, 59. No, Mr. Kumar, he has been informed. Okay. Okay.
my prayer for listing this matter, Your Lordship. Next week, Your Lordship, any date for admission, Your Lordship.
What is the subject
This is the
matter?
matter of Jal Jeevan Mission, Your Lordship. Due to pending of this requisition, no one is the
Matter of which year?
2023, Your Lordship.
20?
23, Your Lordship. Jal Jeevan Mission.
No, why out of turn listing?
Lordship, this due pendency of this
Mention means
requisition.
out of turn listing. Otherwise, also listing is there. You mention matters which are urgent in nature. Sorry, next.
May I please the Lordship, my lord, I beg to mention
Please.
item number 50, my lord.
50.
50. I am appearing for the health department, my lord. The petitioner is also there, my lord. In this matter, my lord, the grievance of the petitioner is taken up by the department, my lord, to redress their grievances. But some time may be granted, my lord.
Madam?
I prefer.
Okay. Sri D.P. Bora, Learned Standing Council, Health and Family Welfare Department, submits that efforts are being taken for redressal of the grievance of the petitioner by the department. Full stop. Ms. P. Bora, Learned Counsel for the petitioner is present. Para? List. After 4 weeks. List after 4 weeks. No. The matter is accordingly adjourned by 4 weeks. Para? List on 30. 31st. 1, 2, 3, on 27th of 29th, 28th of August. 28,
28th August, my lord, it will be next week, my lord. I will not be there.
then 22nd of August, or 21st of August,
21st, my lord. Yes.
21/8.
Maybe.
Obliged, my lord.
Paper listing for admission, my lord.
What is the subject matter?
Promotion, my lord.
Huh?
Promotion.
Promotion, matter of which year?
23, my lord. 23.
Sorry, next.
My lord, I beg to mention for listing of a my lord requisition, my lord, for the next week, my lord, regarding my lord, is appointment of the my lord LDA, my lord, to the post of LDA, my lord.
Matter of which
Next week,
year?
24, my lord.
Sorry, don't make a mention of out
Well,
of turn
the,
listing unless there is some exceptional urgency.
But there is no interim order, but department has proceeded to
24 matters,
finalize
sorry, there are many matters of 16, 17. We have to give preference to those matters. Yes,
May I please, your lordship, I have to mention for listing with withdrawal column. madam.
withdrawal,
So,
okay.
second
Withdrawal. Friday,
For a pending matter, my lord, the family pension. The
family pension,
family
okay, matter of which year?
78 years. Matter of 2023. At
Okay,
last,
pension matter we'll have
Monday.
Monday next.
I would like to.
Okay.
It is a lordship. Lordship, I beg to match withdrawal of item 41 lordship.
You want to withdraw?
Lordship.
What is your name?
P. Borua on behalf of SSC lordship.
You are not on record, madam.
No.
As Mr. Sahola has been informed,
Lordship, actually, the bank has complied the order, lordship. It's a
somebody is appearing for the other side. Have you informed them? You have to inform them. Then make a mention. Do not make a mention without informing. Inform them and come back.
Sure.
Yes,
May please, Your Honor. I like to mention item number 20, Your Honor.
20.
20, yes.
Yes, what is it?
It may be passed over for the day, Your Honor. The
Why?
engaged counsel asked him to mother or grandmother recently expired.
Okay. A prayer for, standing council BSNL, who is for BSNL? Anybody, is there a standing council or CGC? Have you informed the standing council, BSNL?
Not yet,
Huh?
not yet.
You have to inform, we'll accommodate, don't worry, but you have to inform first, not at this hour. Yes,
My lord, I have to mention for listing on repetition, your lordship,
for
for order matters, your lordship.
order, matter of which year?
22, your lordship,
22,
23. lord.
20, what is the subject matter?
My lord, this is common by the matters, my lord, the respondent authority is going to
Sorry,
appoint
no,
one
no,
private
not
respondent
out of turn
who
listing,
is not
sorry,
entitled to get.
not out of turn listing, sorry, yes,
Sir, lordship, prayer for listing. The matter pertains to non-payment of superannuation pension.
okay, matter of which year?
23.
Okay, Monday next, pension matter.
My lord, this matter pertains to family pension. This matter is 22 matter, my lord.
90, Monday next.
Obliged.
Lordship, I beg to, with consent of the other side, I beg to mention item number 40 of today's list.
40,
Yes, sir. My
yes,
lord, yesterday the respondents have filed a detailed affidavit in opposition, and as such, sir, I'm praying for 2 weeks' time to file a reply.
40, PNB, have you informed them?
Yes, my lord. I am for the defendant.
Okay. You're for the respondent, not the defendant.
Respondent.
In a writ petition, it's the respondent, okay? You are, what is your name?
Lordship, my name is Oruna Borua.
You are with Mr. Chaudhary?
Yes, on behalf of,
Oh, Sri A. Barua, learned counsel, appearing on instruction of Sri M. K. Chaudhary, senior counsel for the petitioner, submits that affidavit in opposition has been filed by the respondent bank only yesterday. He accordingly prays for, he prays for, and accordingly granted 3 weeks' time to obtain instructions / file affidavit in reply. Yes, 3 weeks.
Much obliged.
My pleasure, lordship. I beg to mention for listing of a matter, lordship. Matter pertains to regularization of service, lordship.
Matter of which year?
23, lordship.
Sorry.
Where pleasure, lordship, I beg to mention item number 41, lordship.
Yes.
The order has already been complied, lordship.
Have you informed the other side?
I will inform lordship.
We will not do, inform first. This was mentioned right now. We had asked you to inform. Somebody has mentioned right now. Inform and come. We'll accommodate.
Not public, but. May I please, lordship? Lordship, I beg to mention for listing up of 2 matters, lordship. Matters are of 2018, lordship.
18 matter. Okay, we'll have it.
Yes.
Wednesday next.
May please, Your Lordship. Lordship, I beg to mention a repetition for orders.
Matter?
The matter pertains to Pension, your lordship.
Pension, okay, Monday next.
May I please, your lordship? I beg to mention item 53, lordship, from
Yes.
hearing list.
Yes,
As my senior, Mr. I. Rafiq is out of session due to medical emergency, lordship.
okay. Yes, government. Okay, 53. Prayer for adjournment has been made on behalf of Sri I. Rafiq, learned counsel for the petitioner, who is stated to be who is absent because of some medical urgency. Full stop para. List after 2 weeks.
2 weeks. Okay, lordship.
2 weeks. Yes, next.
May I please, Lord? Therefore, listing lordship for admission column.
And what subject matter?
The matter relating lordship petitioner removed from service lordship by the disciplinary authority.
Matter of which year?
2024 lord.
Sorry. Yes,
Lordship,
next.
lordship, opposite party file the affidavit.
Let
lordship.
them file the affidavit, it will come in its
Then
usual
after,
course.
I have already filed the reply, lord.
Maybe. Why should you mention a matter? It doesn't be, it's not listed otherwise.
Yes, lordship.
Then- Why is the mentioning for? Only for extraordinary matters. Yes, next.
Lordship mentioned for listing.
What matter?
Pension matter, lordship.
Pension matter, we'll have it Monday.
Okay.
May I please, your lordship? Item number 20, I will let you mention.
You have informed.
Actually, this is a first case, your honor. Notice hasn't been issued yet.
No, there is standing council BSNL.
And this is a first.
You wait for your turn, we'll accommodate, don't worry.
Okay, okay.
We'll grant the adjournment, but not in the presence of the council. Otherwise, you have to inform him and come. Yes, madam.
Please, your lordship. Lordship, I beg to mention for listing. Lordship, the matter pertains to regularization of service. Regularization,
Regularization, matter of which year?
24.
24 matter, not our case for out of turn listing, sorry. Next.
May I please, your lordship? Lordship, I beg to mention item number 44 and 45.
Yes,
Kindly pass for the day.
Passover.
My lord.
Why?
There is some inconvenience in our part, madam.
You are for whom?
B. Bhuya.
For the petitioner.
Yes, madam.
Inform the other side.
No, madam.
If you have to inform the other side, yes, Mr. Dhar, you are appealing. 44 and 45?
Yes.
Okay. A prayer for adjournment has been made on behalf of the petitioner. Para, list after 2 weeks. 2 weeks.
Okay.
Yes.
Please leave the lordship. Lordship, I beg to mention a repetition for listing lordship. Matter pertains to departmental property.
Fresh matter.
No, lordship.
Then
2023 is for.
23 matter. What is the stage now? Affidavit exchanged.
Lordship, she was punished of dropping 1 year annual approved.
No. What is the stage now? Affidavit exchange or not? Affidavit is filed or not?
Affidavit is filed, lordship.
Who has filed? Not a matter of out of turn listing, madam. It will come on its own course. Yes, next.
I didn't want.
My lord, I'm extremely sorry, my lord. Earlier occasion, my name was not shown. That is why, my lord, when message I got, my lord, then only I came to know. And it was informed to the register, my lord. Then ultimately my name has been shown today itself, my lord. My lord, I'm extremely sorry for that, my lord.
No, your name was shown.
No, as now only it has been shown. Earlier,
No, if
In
your
the
names
first list-
were not shown, we'll record
In-
that.
in the
We are not
first
so
list,
insensitive.
no, in the
They will record none appears in, even if names are not shown.
in the cause list, it was not shown. In the order sheet, it was shown.
Let us see the cause list of the last occasion.
Since today I am appearing, my lord, yes,
No, that's not a problem.
Yes,
But your name was shown, if you remember correctly. And 2 occasions you were absent.
yes, my lord, that is lordship.
Not on the last occasion, even on the last occasion.
Okay.
Okay, what is the matter? I will not be bogged down by those things. Yes.
I got case to yesterday.
What is the matter?
Matter, my lord, here, my lord, this order was passed passed by the single bench, my lord, and against that, my lord, they have filed an appeal, my lord. And the appeal is pending, my lord. Since then, 2019, it was, and this appeal was admitted in 2021. Since then, it is pending. All along, my lord, there was no stay order, my lord. And last occasion, when matter was listed, I've been told by the honorable division bench that whether you have filed a contempt petition or not, you should do it. And that is, my lord, I was on the legitimate expectation that matter would be disposed of accordingly, it will be filed. But when the honorable court has said, and accordingly, my lord, the petitioner has come forward, my lord, to file this contempt petition.
But order is of which year?
Order of 2019, my lord.
How do you overcome limitation?
My lord, since matter is pending before the honorable division bench.
So
my
it is
lord.
still pending.
Yes.
If it was not maintainable then, it is still not maintainable now.
No, my lord, since this honorable court has said, my lord, I have stated, my lord.
Where?
12, para 12, my lord.
Show the order. Show the order.
That was
How do you overcome a statutory provision of limitation?
yes.
19 matter, you are coming for contempt in 2024.
No, statutory provisions, my lord, there is a
No,
provision.
explain us.
1 year, my lord.
Then
That is 1 year, my lord. Now, my
you
lord,
wait for the outcome of the appeal. If the appeal is dismissed, it will be a fresh cause of action from the date of dismissal of the appeal. If you think that there is no stay order, you should have come immediately.
yes, lordship is correct. My lord, I was also expecting the same way, my lord. In the
Your
same way.
expectation will not do. How do you overcome limitation? Tell
since-
us, convince us.
Since this honorable division bench has said, my lord, that
Sorry.
so let only my lord, my prayer, my lord, since in the 2004 1 SCC,
Limitation Act. Limitation Act. Oh, sorry, contempt of court.
2004 1 SCC, it has been said, lordship is aware that from the date of knowledge, the period will be counted. The limitation.
Why are you citing this?
No, I'm not citing, my lord.
How is it relevant?
Yes, it's not relevant, my lord. Only thing is
The
this, my
order
lord.
passed in your case and you are asking about knowledge.
My lord,
How is it relevant?
yes.
It's a
Only
chicken.
my
Let us, I think. Now let's see, no?
section 19, lord.
We are dismissing this on limitation ground. Heard Sri B. Chetri, learned
Then the
counsel for the petitioner who by means of this petition has alleged willful and deliberate disobedience of the order dated 28/2/2019 and 10/6/2019 passed in WPC 2461 of 2016 and in IS civil number, we have not even given the number, IS civil number so and so of 2019. Full stop. Para.
retail number, lordship is pending, my lord. That
Parenthesis, comma, the, no, parenthesis, X faces, comma, the application has been filed beyond the prescribed period of limitation as laid down in section 20 of the Contempt of Courts Act 1971. Full stop. The said Act of 1971 is a self-contained code whereby limitation has been prescribed. Full stop. Para. Sri Chetri has submitted that a writ appeal is pending so far as the orders concerned, orders in question are concerned. Full stop. Pendency of the writ appeal shall not extend the period of limitation. Full stop. It will be a different matter if such an application is filed after disposal of the writ appeal said to have been pending. Full stop. In view of the above, petition is dismissed on the grounds of limitation. Yes. Next.
actually I'm with your lordship's view, my lord. I was also in the same way, my lord.
Next. Yes, what is this?
I'm sorry, my lord.
Well, direction was issued to the respondent to communicate the decision of the medical board.
Page.
Page, my lord, page 10, paragraph 5.
Paragraph 5, yes.
Then I submitted two representation to the secretary as well as medical board chairman.
Who is the chairman of the medical board secretary?
Yes, my lord.
Hmm?
Secretary, he has published the list rejecting my name, my lord. And
No, but what was the direction?
direction was
Only
issued,
to communicate the decision. It has been conveyed to you,
not communicated,
not yet communicated.
not yet.
No, you said that your name has been rejected.
My lord, first, my name was appeared for medical board
Oh, that
examination.
rejection of the subject matter in the writ petition.
Yes.
Okay. Heard Sri N. Sharma, learned counsel for the petitioner who has alleged willful and deliberate non-compliance of the order dated so-and-so passed in so-and-so. Full stop. The learned counsel has also drawn the attention of this court to the representations issued. Representation. Why have you given two copies? Okay, state
Well,
okay. Representations to the
Secretary and
respondents for the para. Let notice be issued. No? Returnable 4 weeks. Steps by registered post with AD. Steps within 2 days.
I look.
Take registered post AD.
Yes.
Item.
May it please the Lord. Contempt petition, my lord. Order lost till fine at page 12, my lord. 11% page 21. Paragraph 20.
Paragraph
20.
20. Review DPC. To hold review DPC.
My lord.
To hold review DPC.
Review the story.
But the matter is order is of which year?
2015.
Then
My lord, they preferred the Union of India, my lord, they preferred, my lord, at the appeal before this honorable court.
appeal has been disposed on
Appeal
17.
dismissed. Then they went up to my lord, they filed SLP.
Okay.
SLP was also dismissed.
When?
SLP was dismissed on my lord 12/12/2023, my lord.
12/12/23.
My lord.
Have you given the order?
My lord.
Where?
Page 30, my lord.
30.
Page 30, 30.
Okay.
This is two SLP was my lord, dismissed together, my lord. This has been my SLP was tagged with this SLP, my lord. Tag order I have connected.
That order?
That order, my lord,
Where is the case? Your case?
my case is, my lord, page 33, my lord.
Your Balak Singh?
Yes, my lord. By this order, my lord, my case was tagged along with this SLP at page 30. Both this SLPs of this.
Tag with diary number 42274
Yes, my lord.
is this case.
Yes, my lord. It is page 32, my lord. Page 32 is the relates to my lord, Hiraj Kumar, my lord. SLP diary lost will fine 42274.
No, this is the not the dismissal order.
This is not the dismissal order. my
Dismissal
lord.
order is at page
Page
30.
31.
30.
30, my lord.
30. Where is 4224?
My lord, this is the SLP number, my lord. Now
Understood. How is the connection? Is it have you stated anywhere that 4224 diary is connected to SLP 2465?
So will find that
Viraj Kumar.
judgment, my lord.
Okay.
This is impugn
Okay,
final.
okay. No, you have made a statement. Okay.
My lord.
Heard. Sri I.H. Shekya, learned counsel for the petitioner who has alleged willful and deliberate disobedience of the order that is so-and-so, passed in so-and-so, huh? It is submitted that the order in question was unsuccessfully appealed before the Honorable Division Bench and thereafter also in the Honorable Supreme Court, full stop. The Honorable Supreme Court has dismissed the appeal on 12/12/2023 along with some other connected cases. Put the para. Notice, 4 weeks. Register post to this.
Published, my
My please, your lordship. My lord, judgment is at page 13, my lord. Operating part, my lord, page 7, my lord. Page 16, para 7.
Yes. Okay. Not done.
My lord.
Part 3 M Islam. Learned counsel for the petition who by means of this, the learned counsel has drawn the attention of this court to the representation submitted on 13/2/2024. Notice of motion, 4 weeks. Registered post with AD. Take steps within 2 days.
My lord.
Why have you made all the parties?
My lord, for abandoned question, I have filed, my lord. At least, my lord.
No, contempt is you are alleging contempt means there are penal consequences. You just cannot make everybody a party here.
My lord, in the paragraph 7, my lord, studying the respondent.
No, once you issue notice, that means we are prima having a view that there is a contempt. It's not proper.
Only at the system, maybe you should notice to the, my lord, Commissioner Panchayat and, my lord, Director of Pension, my lord, 3 and 4, my lord.
1 and 2.
My lord, 1 and 2, my lord, the Principal Secretary to the Panchayat, my lord. 2 is the, my lord, the pension and public grievances, my lord.
4, Director of Pension.
Director of Pension, my lord.
5 is the executive officer. Why are you making 5 executive officer? What role he has got? Then 6 is treasury officer. He has got no role in. He's the authority who will make the consequential, will take the consequential action. Why make him a party?
Well, at this system, maybe you should only 2. my lord.
At this stage, notice is restricted to respond numbers.
3 and 4, my lord.
1, why not Principal Secretary? Commissioner and Secretary, the Public Grants, Director. You have made the Principal Secretary as well as the Commissioner of PNRD party.
Yeah.
2 respond numbers 1, 2, 3 and 4. 1 to 4.
My lord.
What is I?
My lord, I have for, my lord, the Principal Secretary to the Government of Assam Finance Department, the post is lying vacant, my lord. So, my lord, Commissioner and Secretary is doing the, my lord, functions, my lord. So, my lord, that is, my lord, why, my lord, I is filed for impleading the, my lord, Commissioner and Secretary in by replacing the, my lord, in place of, my lord, the Principal Secretary to the, my lord, Finance Department, my lord.
Have you made him a party here in the origin?
Yes, your lordship.
Where?
My lord, can you see the respondent number 3 of, my lord, page 13, my lord, order dated, my lord.
No, in the list of parties, where is the Finance Department?
Finance Department is, my lord, in the IA, my lord.
I understood.
My lord,
You said you are replacing somebody.
7, as a 7, my lord.
7.
My lord.
There is no 7 here.
My lord, I have not made party of, my lord, Principal Secretary in the, my lord, contempt petition. And that is why, my lord, I have filed the, my lord, I have for impleading the, my lord, Commissioner and Secretary to this, my lord, contempt petition.
You have sent notice to him.
Yes, your lordship. Kindly see the page, my lord, page 13.
Okay, you write I, huh? Third, 3M Islam Learned Council for the applicant petitioner, who by means of this petition has prayed for impleading the aforesaid incumbent as the respondent number
Seven.
7.
7 minutes.
Who's the incumbent name? Okay.
Name is no allowed.
Okay, 808, incumbent 8, wrong remark question. The learned council has also drawn the attention of this court to the communication issued to the said incumbent. Full stop para. The prayer for impleadment is allowed. I stands disposed of. Allowed. Petitioner is required to file amended cost title in the contempt petition. I think the first order will pass not today. You file amended, then we have to issue notice to 7 also. At this stage, it will not be proper. Okay. In the contempt petition, wide order dated so and so. Order date passed today. Wide order passed today, that is so and so date. In IA, so and so, the following incumbent has been impleaded as respondent number 7. Nam to Didiba Gutekin here. Joint Nalekane Kiba. Petition, learned counsel for the petitioner is required to file amended cost title within a period of a week.
Right.
Para, list this case for motion after a week.
Highly obliged, my lord.
We have not issued any notice in the contempt.
May please, matter relates to the pension as well as area salary of the petitioner lordship. In the year 2020, petitioner retired from service. Earlier,
Retired as
peon from the learned chief judicial office of the chief judicial magistrate. He was the peon of a government pleader.
peon of a government pleader.
Government pleader. Office of
Is
the
it a government job?
government job.
Okay.
Appointment letter was sent in
Third, Shri ABT Hawk, learned counsel for the petitioner, who is aggrieved by non-payment of his retirement benefits. Full stop. The petitioner claims to be appointed, claims to be serving as a peon addressed to the government pleader in the office of the deputy commissioner. In the office of deputy commissioner, NC Hills, and has retired on superannuation, on attaining the age of superannuation on 30/9/2020. Let notice be issued, returnable by 4 weeks. Mr. Bora, for
I pay for respondent number 1, 2, 4, 5. 1 to 4 and 5.
D. Bora, State Council. Then 3, Finance. Your name is A. Sharma. For that 6, no, Finance. Who is for Finance?
So P. Nayak was he was just here.
Okay. P. Nayak, respond number 3. Standing Council Finance, respond number 3. And A. Sharma, learned Standing Council, appearing on instruction of Sri B. Chakraborty, Standing Council AZ Assam for respond number 6. Extra copies by tomorrow.
May I please, Lord. My lord, here in the case, my lord, the petitioner was working as a head assistant, my lord.
Yes, madam.
Lordship, my senior is on lag, so kindly take the time.
What is the matter?
Matter, my lord, firstly, my lord, there was a departmental proceeding, there was a show cause that has been withdrawn Then subsequently, I have been placed under suspension. Then, my lord, the very person who is the appointed as an inquiry officer, he has,
Oh, what is 11/6/2024?
my lord,
What is 11/6/2024?
I
Which-
think,
11/6/2024, what is this order? You're praying for stay of 11/6/2024.
no, my lord, I'm challenging, my lord, the order dated page 137.
No, we are on the stay prayer. You are praying for stay.
My lord. I challenge, my lord, 2/3/27, page 237,
6/6.
my lord. 6/6, thereafter,
That is-
my lord, another letter was also issued to me, my lord, asking me to join for that post, my lord. And I have filed my appeal also, my lord, appeal also discarded, then, my lord, I have filed a writ petition.
Posted. You are challenging a posting order.
My
Why?
lord, because, my lord, I challenge my appeal also, my lord, appeal your lordship fixed on 18, my lord. Thereafter, my lord, in the meantime, they have issued this order, my lord. Page 337, asking me to join somewhere else, man. I was the head assistant, my rank was reduced from head assistant to senior assistant,
Yes, let Mr. Das come.
my lord.
Call Mr. Das after a while. After a while.
My lord.
Item 7. Education matter, why?
No, my lord,
Bench
why?
2.
It is bench 2.
It is submitted that this matter pertains to civil bench 2. List before the appropriate bench.
Keep
Yes,
your date.
yes.
No, bless.
8.
May it please your lordship.
Yes.
But, this pertains to a departmental proceeding, my lord, initiated by the bank.
Okay.
Where, my lord, I was not given the documents that I was asking for. And I was raising a complaint against the inquiry officer that we have some personal enmity. So I have made a written request to change the inquiry officer and to provide with the documents. In last occasion, my lord, my learned friend appeared on behalf of the bank. And he was supposed to take the instructions from the authority concerned.
How do you stop a departmental proceeding?
Pardon, my lord.
How do you stop a departmental
My
proceeding?
lord, if my lord, they have not provided the documents that are,
Good, this will be a ground for you to challenge. If you have asked for the document, it is on record that even after asking,
it was
they have
not
not, even after asking, they have not given you the documents. Good case for you.
my lord, I have gone to a lordship's judgment in Malik Uddin. That was a few days
But
back.
that cannot be a ground to, it will be premature. It will be a very good ground for you to challenge if assuming that they take a step adverse to you.
My lord, in that case also, that it may cause irreversible prejudice.
What
to-
irreversible? This is a measure of law. If they are taking on their own risk, on their own peril, you have asked, you are asking whether there is on record that you have asked. You said yes. Nothing. You're protected.
That's correct. My lord. The law also,
Mr. Goswami,
My lord, may kindly peruse the last order.
of this court.
Yes.
24/7.
Yes, my lord, 24/7.
Yes, 6.
His basic case is that, my lord, certain documents were not furnished to him and the inquiry officer is, according to him, is biased against him.
Hmm.
So,
You have taken instructions on these two
yes, my
points.
lord, I had written a letter, my lord,
Yes.
bank has agreed, my lord, that they are, in fact, my lord, these documents are being furnished to him. Yesterday, the peon went to his house, his mother refused to accept it. And, my lord, we have also decided to change the inquiry. Whatever his grievances were, my lord, all are taken care of. This is the instruction. So my only prayer would be, my lord, let my friend, my lord,
Mr.
accept.
Goswami, you should appear in all cases.
We don't want
Dependency will come down. First the disposal, without there being any
we
adjudication.
don't want to get this DP stayed, my lord. Let him
No,
participate.
no,
Whatever,
otherwise also we are not staying.
whatever his grievances. This is a letter, my lord, written to him, copy marked to me, my lord, with a reference to the last order.
Advise your client to have the documents My lord,
His
yesterday,
copy, his client, my lord, I am also holding that original copy. He can also accept, madam.
well, I can accept it. My lord, the thing is that he's making a statement on written instructions that they're changing the inquiry officer. That's right,
Yes,
my lord. Until then, my lord, they should not proceed with the
definitely, madam. That's already there.
Obviously. Heard Sri A. Chamo, learned counsel for the petitioner, who by means of this application has put to challenge the initiation and continuation of a disciplinary proceeding. Full stop. The said proceeding has been initiated by show cause notice dated 6/11/2023. Full stop. The principal grounds of challenge is that are that the documents asked for by the petitioner were not furnished to him. And secondly, the inquiry officer who was appointed was biased.
Well, there are three grounds.
Third
That
one?
your lordship just
Third-
pronounced.
Third,
Third was that is the managing director, was the center figure of the whole dispute. He becomes the person who issued the so-called notice.
It's a disciplinary authority, madam.
That one ground that is left.
After disciplinary authority.
additionally, it is also contended that the disciplinary authority is himself biased towards the petitioner, as he is also involved. Is he involved?
Yes.
And he is also involved in the alleged misdeeds, misconduct. What's the para? Be that as it may, comma, this court vide the last order dated. Last order dated 24/7/2024 had directed Sri T.N. Goswami, learned standing counsel of the respondent bank, to obtain instructions on the aforesaid two principal grounds. Full stop para. Sri Goswami, the learned standing counsel, has submitted on instructions that both the principal grounds have been redressed. Full stop. Firstly, he submits that the copies of the documents were sent to the address of the petitioner, which was however refused. Full stop. He has also submitted that the inquiry officer is being changed.
He's being changed and he will be intimated about it.
Changed, and such change would be informed to the petitioner. Full stop. Sri Goswami has also placed on record a copy of the letter dated 30/7/2024 issued by the respondent bank to the petitioner. Full stop para.
Hello.
Since it is submitted that the documents which were sent to the petitioner to his residence were refused to be accepted by a relative of his.
I was absent.
A relative of his, Sri Chamua, the learned counsel, has accepted the bunch of the documents in the court itself. Full stop. This court has already recorded the submission of Sri Goswami regarding the change in the inquiry officer. Full stop. Para, in view of the above, this court is of the opinion that this writ petition is no longer required to be continued, and the same is accordingly closed. Full stop. As regards the third ground of challenge, the same would be open to be agitated as and when required.
Well, just one sentence, if lordship pleases. Until the new inquiry officer
That we
comes into
cannot
place.
proceed. Things to
Cannot be
that
proceeded.
there is no requirement.
It is needless to state that the inquiry would proceed only after
Appointment of the
appointment of the new inquiry
Fine.
officer.
This
Obliged.
letter dated 37/2024 may form part of this proceeding.
The communication that 37/2024 mentioned above is made part of the records.
Fine.
Deep level.
Okay.
May I please your lordship, on 24/7 lordship, they were directed to take instruction regarding the appeal which I have filed after my dismissal order, lordship.
My instruction is, my lord, the DP has been disposed of, but regarding appeal matter, I have not received any instruction. We have received instruction 25th of July 2024. It has been, my lord, stated that it has been disposed of and the DP file sent to the Deputy Inspector General of Police SR, the appellate authority, as desired by him 22nd 7 2024. Appellate authority by data 18/7.
We'll issue notice here and we'll make an observation that any
appeal-
decision taken in the appeal would be subject to the outcome of this petition. If you get relief in the appeal, you can withdraw this petition.
Lordship, and the lordship pendency shall not be about to dispose of my appeal in the meantime.
Heard, Ms. S. Kanungo, learned counsel for the petitioner, who by means of this petition has put to challenge an order of dismissal from service dated 21/6/2024. Full stop. It is submitted that the petitioner was working as
ASI.
Assistant Sub-Inspector in the Assam Police and
UBU.
was also arrested in connection with a case under the Prevention of Corruption Act 1988, whereafter the proceeding was initiated, culminating in the order of dismissal. Full stop. The learned counsel has informed that against the order of dismissal, comma, a departmental appeal has been filed, which is pending. Full stop. Para. Let rule be issued, returnable by 6 weeks. Chutia for all?
Yes, doctor, for all.
Sri Tichi Chutia, learned additional senior advocate Assam, accepts notice on behalf of all the respondents. Let extra copies be served upon him within 2 days. Para. Sri Chutia shall also obtain the records of the disciplinary proceeding. Para. Pendency of this writ petition shall not be a bar to consider and dispose of the departmental appeal in accordance with law.
My lord, the issue involved here whether simultaneously criminal proceeding and departmental.
Yes,
proceeding.
last date,
Last date, my lord, my learned senior colleague raised an objection as to whether the departmental proceeding has concluded or not. So it is on the court directed him to appeal.
Yes, sir. I have received the instruction, my lord, yesterday. The departmental proceeding is not completed. My lord, they have added one in the statute, my lord, one additional witnesses and an additional document. That's why they have appointed the inquiry officer and presiding officer on June 2024.
Not proceeded. Okay.
And additional, my lord, they have received some additional, my lord, document and additional witnesses that has been added in the departmental proceeding.
Okay.
Directed to department document.
Okay.
One
but,
additional document and additional witnesses have been added in the Stokoe notice. My lord,
we'll issue notice and stay for the time being. And we'll follow tangent.
Yes, the lordship will pass this order. So far, my lord, this subject to correction, my lord, lordship has lordship also held that, but this should not be. My lord, in my lord cases, my lord, I have seen one case, my lord, decided on 16 March 2022, Richard EN2, as the Union of India. In this case, what happened, my lord, the Guwahati High Court passed the order. One observation is there, man. May I read it, my lord?
Please.
I have a copy also. In the instance case, the senior additional advocate general submits that within a period of 6 months from the death, endeavors shall be made to complete the disciplinary proceedings within the state period. Taking into account the facts of the instance case, the charges leveled against the petitioner, the judgment of the Supreme Court in Appeals versus so stand taken by the government of Nagaland to the effect that they would make every endeavor to complete the said disciplinary proceedings within a period of 6 months. We are of the opinion that interference with the said disciplinary proceedings at this stage would be would not be in the interest of justice. Moreover, when the Supreme Court in the case of Akhilesh Shah had categorically observed that such course of action was clearly impermissible. From the point of prejudice caused to the petitioner, we have perused the pending pleadings, and there is nothing shown how the petitioner has been prejudiced in defending himself in the disciplinary proceeding. As already stated here in above, the prejudice caused has to be demonstrated and cannot be pity on something. That is, in the pleadings, nothing in the pleadings. I am getting two questions.
Let us see the here. What is the
That
stage
is
of
not pleaded in this case.
Mr. Patwari? What is the stage of the criminal case?
My lord, supplementary charge sheet has been,
Do you have you annexed the charge sheet?
yes,
Let us see the allegation and the allegation in your
yes, yes,
DP.
already there in the pleading. The
Page
supplementary charge sheet starts at page 25, my lord,
25.
25.
Yes.
Lord, will they kindly turn to page 27.
Yes.
Accused number 76 is the writ petitioner, Shahjahan Sarkar.
Yes.
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 Now, Lordship will kindly turn to,
Where do you get the
yes,
allegations?
at page 48, my lord,
48.
48, same part of the same supplementary charge sheet.
Yes.
May I read para 17.13, my lord? During investigation, the specimen handwriting and signature of the accused A76 were,
A76 is the petitioner.
yes, Shahjahan Sarkar. At page 27, Lordship will find that.
Yes.
17.30.
The FSL report has been received from the authority of the FSL. As per the said FSL report dated so and so, it is established that the handwritings appeared in the aforesaid false and transcript of accused A76 are by none other than himself, that is A76. Thus, accused A76 has obtained the job of APS junior grade in the Assam government through APSC by adopting illegal means and corrupt practices. As already mentioned in the above, the accused Rakesh Paul was the chairman. The Pavitra Kaivatra was the.
Where is your
Yes,
list of allegation in
yes.
the
Lordship
DP?
Lordship will kindly read the last portion also.
No, list of allegation in
The
the
allegation is there,
in the DP.
one
No,
man.
Lordship will first let me complete.
No,
one.
we have seen this.
The para, next para also, my
No,
lord.
we've seen this. We just want to see.
Yes, my lord. The so-called notice here, Lordship will find that it starts at, my lord, page 69.
69. The one man committee.
Not 69.
Customers report.
69 is your written statement.
69, no?
Yes.
No, 69. no.
Where is the so-called?
At page 57, my lord, I'm sorry. Annex 4,
It's the
57.
30th number.
And the statement of allegation is at page 59, 59.
And where are your pleadings?
Yes, madam.
No, this allegations are same.
Yes,
It
madam.
originates from the same source.
Same, but the same in one may not be, my lord. Maybe to some extent, I don't know, my lord. I have not received a report. So this one man commission has, my lord, already had it. And now this case has the flavor of the Rakesh Pal. Rakesh Pal now is convicted for 14 years.
No, that is a different case.
ADO.
In this case, supplementary charge sheet has also already been filed.
Yes.
His involvement in this case, we cannot presume
No,
that he will be.
I am saying, what is the prejudice that is not specifically mentioned here?
No. If he has to disclose his defense in the disciplinary proceeding, he will be prejudiced in the criminal
The
case.
suppose, my lord, criminal case is pending for a long time.
That is what Stengen has said.
Yes.
1 year maximum.
That is, my lord, that is the, my lord. Yes.
Stengen Toitetsu.
Yes. That's why they have observation, my lord.
Yes,
Direct, Supreme Court,
maximum 1 year.
yes,
Maximum.
Supreme Court also directed the criminal case should be as soon as possible be disposed
Yes.
of.
Now, we also do not want an indefinite period criminal case
Yes,
made
yes,
to make,
not the penalty, the next page,
but at least for the first year, we should give time.
extension, my lord. So I have
Extension.
paragraph
Yes.
16.
Yes,
La-
yes, you are
last
correct,
paragraph.
correct.
I'm reading.
Heard Sri J. Patwari, learned counsel for the petitioner. Full stop. On the last occasion, that is 26/7/2024, the following order was passed. Full stop. Para. Sri Chichi Chutia, the learned court Kodiva, the learned addition senior advocate Assam has submitted that the status of the disciplinary proceeding is at the stage of appointment of inquiry officer
Inquiry officer
and
and
presenting officer. Full stop. Para. Let notice be issued. No, he has also submitted that unless the charge in the criminal case and the allegations in the disciplinary proceeding are the same, comma, there is no requirement, and there is no requirement to stay any such disciplinary proceeding. Full stop. He has also submitted that adequate pleadings would be required to substantiate that the charges are the same. Full stop. Para. Let notice be issued, returnable on on 28th of August. We'll have a fixed date since we are passing a stay order. 28th of August 2024. Sri Chotia, the learned State Council accepts notice on behalf of all the respondents. Let extra copies be served upon him by tomorrow. Para. Heard the learned council on the interim prayer. Full stop. Following the law laid down by the Honorable Supreme Court, including the case of Stangen Toyotisu Supra, the further proceeding in the disciplinary proceeding is stayed. Full stop. The aforesaid interim order, however, would be reconsidered on the returnable date.
Deeply applied.
The State Council may also apprise the court regarding the development in the connected criminal case. Okay. Okay.
My lord, item number 11 is accused number 75.
Same.
Same.
Okay, same.
Item 10 accused number 76. Item 11 accused 70.
Respondents are the same.
Same department, same police. Deeply obliged.
Item 12.
Lordship, we have to serve them a copy. Let it come after next week.
Madam Upamanyu, what is your prayer?
Lordship, we have to serve them a copy.
You're for, madam, you're for
Water Resource Department.
water resource.
Yes, sir. Respondent number
Okay.
1, 2, 3, and
Miss Upamanyu, learned counsel. Again, you are not, your name is not there. Learned counsel undertakes to serve a copy to your
DG.
huh?
DG.
D. Jain.
Yes, sir.
Learned counsel appearing on instruction of
Mr. RM Das.
RM Das, standing counsel water resource. Full stop. List on when? Friday?
Yes.
Friday for motion.
Obliged.
Please, O Lord. The petitioner before our lordship, my lord, was duly selected and appointed
As what?
as Jogali, my lord, grade 4 post, my lord.
Hmm.
But unfortunately, my lord, she was not allowed to join, my lord, on the ground that, my lord, while filling up the form, application form, my lord, online form, my lord,
against the column of ex-serviceman category, it was mentioned, yes, my lord, but actually I do not belong to ex-serviceman category, but I belong to SC category, my lord. And my application, my lord, information, kindly see page 27, it is recorded as SC candidate, page 27, my lord.
That is the only ground for not.
That is the only
but
ground.
do you meet the criteria to be appointed in the category of SC?
SC, my lord.
Have you obtained the minimum marks,
Yes, ma'am.
Mr. Bora?
Lordship, at this stage, I should notice, because I don't know, they have not connected that impugn order as to whether they had been not allowed to join on that.
No,
I've been assuming that she is not allowed to join, but if there was a mistake in filling up the form, and actually the petitioner is an SC candidate and not the ex-serviceman, then she has to qualify within the SC category.
The Lordship, to that effect, that particular examination was conducted by the state level recruitment commission board. And for that standing counsel, Mr. B. Chaudhary.
Yes, is it made a party?
No, the name is not reflected.
Name made a party or not?
It has been made a party. They've been made a party.
Okay.
But their name is not reflected in the cost.
Okay, we take this up at 2 o'clock. You serve a copy to Mr. B. Chaudhary, Vikram Chaudhary, and ask him to come at 2 o'clock.
Because they conducted that particular examination. They will be.
No, we'll do nothing, but we'll issue notice in his presence. Because only because he was selected on a particular category, there was an error in, but he has to be selected in this category also. We do not know what was the last marks obtained.
That's good.
Published.
Okay.
Similar.
Yes.
One gets a review yet to be filed, madam.
Review is yet to be filed by the petitioner.
Regarding
Lordship, the dismissal of the petition. Lordship.
Similar matter, madam.
Similar matter by court. This matter was on 24th, Lordship, this matter was listed before this court. So this same order will cover. Lordship.
Yes, same order.
Item 14,
14, 15, 16, and 19.
Same order, huh? 14, 15, 16,
14,
19.
15, 16, and 19.
Department is the same. Mr. Upamanyu?
Lordship, I am for the health department, but the
I am appearing for respondent number 6, director of secretary.
in item.
In item 14, 15,
Item
14 and 15.
14, 15. P. Das. For respondent number 6, director of secondary education.
In item number 15, your lordship. I am appearing-
In these two items, Upamanyu
I
is
am
not
appearing in
appearing.
all the matters.
Health department is a party.
Yes, Lordship, in all the matters.
I am appearing for respondent number 5. For 14 matter, I am appearing for 6, and item 15 matter, I am appearing for respondent 5.
5. But director of secondary education.
Yes, sir.
Standing council education. Standing council education, 14, 15 present. Department. And Mr. Bora, you are also appearing. Bora already met. State council. Bora for all the cases. Episode
Lordship, even I am appearing in all the matters. Lordship, I am
Yes,
appearing.
Sri D. Bora. State. P. Das. Miss P. Das. Standing council. Education at all. 14 and 15. 14, 15. P. Das 14, 15 local thing, huh? Medical set. Okay.
Highly obliged.
Deeply.
16. 16. Ardhar. 16 not. Standing council WPT. Yes. Where? In item? 14, 15. All the cases. Elodha. Social Justice. Department of Social Justice.
Highly
Deep view.
Article 17.
Made visual lordship. Actually, although it is very bulky, I'll make it short, my.
Why you were in a hurry?
No, I'm not in a hurry, my lord.
Then
but
why
it's
do you make it short?
No, because it is very bulky, my lord. Visual lordship will do.
You take your time.
No, it's for like,
We are at your disposal.
today I only one notice, my lord. And what happened, my lord, these are the petitioners, these are, my lord, the VRS of the, my lord, ill soil, my lord, no, my lord, AGCL, Assam Gov Construction Corporation Limited. So, there is a VRS notice was issued, my lord, in 2009.
AGCL, Assam Government Corporation Limited.
Government
Construction Limited.
Corporation Limited.
AGCCL.
My lord. You also kindly say page 240, my lord.
Assam Government Construction Corporation Limited. Yes.
Page 240, my lord.
You are the managing director.
My lord.
You are the managing director.
We had a petitioner, my lord. Petitioner,
No,
they are
you.
the employee.
We are not the petitioner. We are asking you, Mr. Mohanto.
No.
You may be. We do not know what is going on. Mr. Kolita is also giving a mischievous smile. Maybe there is something. Yes, what is it? There was a scheme for voluntary retirement.
Scheme for voluntary retirement.
You opted for voluntary retirement.
Yes, opted for voluntary. You also kindly see that that notice, my lord, 240, page 240, my lord.
240.
240, my lord.
Yes.
So, as your lordship got it, 240, my lord.
Yes.
That was the, my lord, direction that, my lord, you immediately, within 10th of November 2005, you have to apply for the VRS, otherwise you will be thrown out. You will be retensed and you will losing other benefits. So accordingly, my lord, all petitioners, my lord, they applied for VRS. And my lord, in that notice, my lord, your lordship kindly see ex gratia. Now only confined to ex gratia only.
Yes.
Ex gratia, as per AIDC model in existence. So in AIDC model in existence, that point of time, it was for the 30 days. Ex gratia benefit will be 30 days. So after we opted for VRS, that is, my lord, annexer, my lord, page 240 on your lordship kindly see, 15 February 2006. My lord, it is modified. It is reduced to 15 days, 30 days to 15 days, my lord. So that litigation only for that, my lord, the ex gratia which was granted, promised at the time of, my lord, VRS, that is for 30 days, and subsequently, my lord, it was reduced to 15 days.
Which paper?
Paper, it is 241, my lord.
Next page.
Next page, my lord.
2006.
2006. Then, my lord, it was challenged before this honorable court.
Just a minute, please. And this is 240 is dated what? 18 October.
15 February 2006.
No, 240 is 18 October 2005. Page 240.
240 was, yes, my lord.
18 October.
18 October.
Then 241 is
15 February 2006.
15 to 2006. Ex gratia period has been reduced to 15 days.
15 days.
Okay.
So then, my lord, it was challenged before this honorable court.
Yes.
By some of the employees, my lord, about 50, 60 employees, my lord, they approached this honorable court. Writ petition was allowed. Then thereafter the review file. Review dismissed.
Oh, the corporation file review.
Then review dismissed. Then government file appeal and corporation also file appeal before the division then. That is also dismissed. Then they went to Supreme Court.
Okay.
State government went to Supreme Court, and that was also SLP also dismissed, my lord. So now, my lord, the person who, these are the person, my lord, they did not approach this honorable court. Now, my lord, they want the same benefit because it is judgment in RAM, because only that decision was only for 15 days to 30 days to reduce to, that is to all the VRS employees, my lord. But those who are, these are all beyond my and 48 employees, my lord.
They did not came before this honorable court. Now they, after my lord, the judgment of the Supreme Court, my lord, they approached the authority. The same benefit, highly
Supreme
representation,
Court judgment was of which date?
2024, my lord.
You were waiting on the fence, sitting on the fence.
Yes.
No, my lord, that is not, my lord, covered because there is a judgment in RAM, my lord. That covered also, my lord, because
If
when
it
they,
is a judgment in Rome, where are you before the court?
no, they have not
Because-
done it, my lord.
What is the judgment?
No, your lordship kindly see, then we approached the authority. That same benefit will be given to us also. That was dismissed, my lord, very recently, my lord. Against that, I came before this honorable court, my lord.
244, sir.
But why are you so late?
244.
If
244,
the
my
others
lord.
could have come in the year 2006, you have come after around 20 years.
244.
No, we, your lordship kindly see that, my lord, the same benefit, my lord. That is that's notification.
No, if you same benefit, okay, but if you sleep over your rights and you watch the proceeding from far, let us see what is happening. Then suddenly you come up.
No, my lord.
Where is your due diligence?
That
We
is
are
correct,
an
my
equity,
lord.
equity
But,
court.
but when the honorable apex court has already passed the order, we approach them authorities that you just same
Page-
benefit will be page
page-
244, my lord. That was the impleadment order here, my lord. Now, page 244, that was passed very 7th June 2024, my lord.
Okay. Hard. We issue notice of this. Hard. Sri T.J. Mohanta, learned senior counsel for the senior counsel assisted by Sri H. Buragohai for the petitioners. Full stop. The petitioners who are 133 in numbers are praying for the correct computation in the matter of payment of ex gratia. Full stop. It is submitted that the petitioners were grade 4 employees, grade 4 employees of the Assam Government Construction Corporation Limited. And a scheme was introduced for voluntary retirement. Full stop. Since it was stipulated that if the incumbent did not opt for the said scheme, they will be retrenched. Full stop. As a result, the petitioners had given their option for such voluntary retirement. And as a condition thereof, ex gratia payment was to be given as per the existing norms of the AIIDC or AIDC. AIIDC. Full stop. It is submitted that the period was at that point of time 30 days, which was, however, reduced subsequently to 15 days. Full stop. The reduction was successfully challenged by a batch of similarly situated persons in this court, and the review and appeal, including the SLP by the corporation and the state, have been dismissed. Full stop. The petitioner, being similarly placed, had requested for grant of the same benefit, which, however, has been refused by the impugned order dated 7
June 2024.
7/6/2024. Para. Let notice be issued, returnable by 6 weeks. Sri A. Collateral Understanding Council.
1, 2, 3, Lord.
Industries and Commerce Department. Except notice on behalf of respondents 1, 2, and 3. AGC, CC, anyone? Assam government.
Some appeared, but now is not appeared.
I don't think.
Let extra copies be served upon Sri Kolita by tomorrow. Let steps be taken for service of notice upon the respondent numbers 4 and 5 by registered post PTD. Steps leading to this.
My lord, small correction, my lord. Gate 4 and gate 3 mix, my lord.
Okay.
Grade 2 also, grade 2.
And don't say grade 3. Or KSL, where? Grade 4 no, where employees will come.
Employee.
Deep down.
Keep your place. Probably.
May please, Your Lord. My lord, the petitioner was appointed as Assam Civil Service Officer in the year 2019. While on probation, my lord, a departmental proceeding was initiated against her on some negligence, purported negligence allegation. And my lord, after conclusion of the departmental proceeding, a punishment of stoppage of 4 increment was imposed upon her. And after 2.5 years, she has been reinstated in service in the last month. Now, my lord, in the meanwhile, after joining, she has submitted her resignation. However, my lord, instead of accepting her resignation, the government is trying to compel her to work, my lord. That is the
Why?
Your Lordship, let me take instruction. Otherwise, there is a currency of the penalty for increment.
Yeah, just from my
That you can already do.
stoppage of 4
Let's see,
increment.
basically, I don't know the reason.
Let them be instruction. I will
We
try-
issue a short notice.
Yes.
Okay. Heard Sri J. Patwari, learned counsel for the petitioner. Full stop. It is the case of the petitioner that in the year 2019, she was appointed into the Assam Civil Services. Full stop. However, a departmental proceeding was initiated against her, which had culminated in an order dated 3/5/2024 by imposition of penalty of withholding of 4 increments with cumulative effect. Full stop. Though the petitioner has been reinstated on 5/6/2024, she had tendered her resignation on 14/6/2024, which however has not been accepted. Full stop. Para. That notice be issued, returnable on 19th of August. Short notice. Mr. Bora for all?
All the time.
Sri D. Bora, State Council access for all. Extra copies by tomorrow.
deeply.
Item 6.
Please, Your Lordship. My lord, here is the case is that my lord petitioner was working as a head assistant, my lord. Thereafter, my lord, one complaint was lost, my lord. Then they have inquired it and they found nothing. Accordingly, their focus was withdrawn. Thereafter, I was placed under suspension. I have replied my lord, and they have appointed one inquiry officer, one presenting officer. And inquiry officer, he himself is a, my lord, complainant of the case. He submitted a report by the presenting officer, my lord. Upon that, my lord, I was given a penalty reduction of my rank, my lord, from head assistant to my senior assistant. Then, my lord, I filed a
The
writ petition.
disciplinary proceeding was completed.
Completed, and I have filed a writ petition also, my lord. And your lordship was pleased to call for the record, my
Head
lord.
assistant to senior
Uh,
assistant.
Head senior assistant, my lord.
From head to senior, you were reduced in your rank.
Rank, my lord.
Thereafter,
Thereafter, my lord, I filed an appeal, my lord, that was discarded. During pendency of the case, my lord, they have submitted a
you
copy
filed writ petition.
by writ petition, my lord. Lordship, kindly have a look that.
Then what happened?
Then, my lord, lordship was pleased to call for the record, my lord. In the meantime, my lord, they have issued this letter. Another letter also they have issued, my lord, asking me to join, my lord, which I have assailed in the instant writ petition, my lord, page 237. That's why I am praying for staying of the case, my lord, that impugn order till your lordship decides the matter on 18, my lord.
No, your joining will not be to the prejudice.
My lord, I have given lower rank.
If you join, it
Your
will.
lordship give me some protection, my lord. At least some kind of protection, my lord. If I join, my lord, my right will be gone for the appeal.
Why?
That observation, lordship,
We'll
kindly give.
we'll make the observation.
My lord, lordship, kindly give us some observation or fix the matter, my lord, along with that writ petition. That can be done. My lord.
Lordship has already called for the record on 19th of.
Yes, we'll take this matter with them
Yes,
and will
but
say that
till
his
then, my lord,
joining
no action.
will not be to the prejudice of either of the parties. Will protect your interest of the department also.
Yes, my lord.
Heard Sri G.I. Borbuya. Learned. What is the cause of action in this petition?
My lord, this
Which
cause
page?
of action in the
Page
237.
237.
My lord, annexure 33.
Okay, the joining, okay. Heard Sri J.I. Borbuya, learned counsel for the petitioner. Full stop. The petitioner was imposed a penalty of reduction in rank from the post of head assistant to senior assistant after a disciplinary proceeding, which itself is the specific matter of challenge in another writ petition filed by the petitioner, being WPC 3583 of 2024. Full stop. The said petition was admitted by this court on 22/7/2024, and the learned standing counsel Sri R.M. Das was directed to produce the records, and the matter has been fixed on 19/8. Full stop.
89, no?
19/8.
Right.
Full stop. The present writ petition has been filed challenging a communication dated 6/6/2024, by which the petitioner has been directed to join in the lower post of senior assistant. Full stop. It is submitted by Sri Borbuya that such joining would cause prejudice to him, as the punishment order itself is the subject matter of challenge in the pending writ petition. Full stop. Para. Let notice be issued returnable on 19/8/2024. Sri R.M. Das for all. Standing counsel, Water Resource Department accepts notice on behalf of all the respondents. Let extra copies be served upon him by tomorrow. Para. Sri Borbuya prays for an interim order. Full stop. Para. This court is, however, of the opinion that no interim order is called for. Full stop. However, it is observed that joining in the post of senior assistant by the petitioner pursuant to the impugned communication would not cause any prejudice to the rights and interest of the petitioner espoused in the earlier writ petition. Full stop. List allowance WPC 3583/2024. Okay, next.
20.
Yes. Any standing counsel of BSNL is there? Did you find any counsel? No. Okay. But why did you write SC BSNL? Was it served upon anybody? Counsel notice come. Second copy. Last page. Notice दिया ना? এটা notice না এটা. Notice नहीं दिया क्या नहीं? नहीं नहीं क्या? क्या SCBSNL लिखी थी वाले? You should not write SCBSNL. What is your name?
R. Lohakar, R.A. Lohakar.
Sri R.A. Lohakar, Learned Counsel, submits that the leading counsel, Sri Sansua, is having some personal difficulty. Full stop. List after a week. For motion. List after Rohit for motion.
Item 21.
Item number?
May it please your lordship. My lord, petitioner, my lord, he was serving as the deputy director, social welfare department in NC Hills, my lord. And he was arrested with a my lord, police case, Bosishta police case number 2070-2009. And because of the harass, my lord, he was put under suspension, my lord. Because of he was harassed, my lord. And my lord, while petitioner in jail in 2012, he was served with a copy of the my lord show cause notice. But he was inside the jail, my lord. So that's why, my lord, that show cause notice was challenged before dishonorable court, and dishonorable court kept it abeyance. That notice was kept in abeyance. So in the meantime, my lord, in the police case, my lord, that was ultimately special court convict him, my lord. And because of the conviction, my lord, and he was dismissed from service. And in the meantime, my lord, he filed an appeal before dishonorable court.
Appeal or writ petition, or in the against the conviction order?
Conviction order, immediate. So that, my lord, in the meantime, dismissal order was also challenged before dishonorable court, my lord.
Okay.
And dismissal order, my lord, and in the meantime, he got acquitted in a criminal case before dishonorable court.
In the appellate court?
Appellate court. So that it was placed before this court, my lord. And ultimately, his dismissal order was set aside, but he was kept in suspension, my lord. So the finding of that earlier judgment, your lordship kindly see.
Now, what is your cause of action now?
Now, cause of action, my lord, your lordship kindly see, as per the direction of this honorable court, they keep me, my lord, in suspension for 3 months. This is the direction. And within this 6 months, you have to apply the Ajay Chaudhury's case, my lord. Your lordship kindly state where goes to page 55, my lord. Page 55, my lord.
Yes. Yes, we have seen this.
Accordingly, the impugned order of dismissal dated 17/5/2018 issued by the Principal Secretary of the Government of Assam Social Welfare Department in set aside. The petitioner be taken back in service forthwith. 2. The respondent employees shall proceed with the departmental proceeding already initiated by issuing search memo number so and so.
Yes, we have seen, you have read this.
Then,
No,
as
we
per,
have read this. Thereafter, what has happened?
therefore, my lord, your lordship kindly see that page 56, the impugned order, my lord.
No.
Page 50. They taken back, my lord, but put me in suspension, my lord. Now, my lord, your lordship kindly see page 58 is the impugned order here. You know? So, as per High Court order, honorably court order.
Yes, page?
No, as per the order of this honorable High Court, my lord, they can put me in 3 months in suspension, and thereafter they have to take a decision as per the Ajay Chaudhury's case. Now, my lord, they issued, my lord, that the page 58, my lord, they again extended, my lord, giving a back date, my lord. Why I am giving it after 90 days, my lord? Your lordship kindly see that order was issued in 4th May 2024. Giving, my lord, without giving any proper explanation why it is, my lord, my suspension has been extended, my lord. Your lordship kindly see page 60, my lord. On review of this entire issue, it is observed that the charge level against the member Mohammad Rasidul Hussain Khan are extremely serious in nature, including interior siphoning of misappropriation of a huge amount of government money. Also, the fact that in spite of the elapse of several years from the date of discussion.
So, what is your grievance now?
My lord.
Grounds of grievance. What is your grievance?
Your lordship kindly see, my lord, that
see,
page 61.
You are reinstated on 26/4/2024.
No, not reinstated. I still am under suspension.
No, reinstated means reinstated in service. You may be under suspension.
Yes.
You are back in service on by the order 26/4/2024, but they have taken a decision that it will be kept under suspension because charges are serious.
But nothing has been given to us, my lord.
Regarding?
Till today, no, my lord, the statement of allegation, no document has been served on me, my lord. Nothing, my lord. Your lordship, no, why I'm submitting, my lord, it is, my lord, is back that there's a reasonable count. Page 61, your lordship, kindly see. They have, my lord, they have dispatched it on 9th, my lord. They booked on 9th. Your lordship, kindly page 61. There is a postal department, my lord, receipt. Consignment, my lord. Because on that day, 90 days is over. They when the order issued on 4th, my lord. But that was, my lord, booked on, your lordship, kindly see, on 9/5. Delivered on, my lord, 10th. So, my lord, after 4 days, my lord, then why they have not, my lord, given send immediately, my lord? They says that, my lord, I am failed to give reply. That was one of the ground.
6.5. Where is the default? We are not being able to understand.
No, my lord, your lordship, kindly see, they says that I failed to give reply. That's why that is the reason, that is the for extension, my lord.
We are not on the grounds of extension. They may have good grounds. We are not judging the justiciability or justifiability of the grounds cited. It's their prerogative. We'll be objectively seeing what grounds have been given. We'll not go into the subjective satisfaction. They have said charges are serious.
No,
Shall we
charges
go
are
into
serious. They should have, they should
No,
have.
that is, but where is the fault? See, the judgment is of 6/2/2024.
My lord.
Has said that till 3 months, he will be still under suspension. And if you have to pass some orders, you have to pass orders by Ajay Chaudhary. They have passed orders on 16/4/2024, which is very much within 3 months.
No, that is, there's a doubt, my lord.
No, 16/4, the first order at page 56.
My lord. No, that is, my lord, regarding my reinstatement, my lord.
Not reinstatements. Kindly see the second last paragraph. However, shall remain in suspension.
My lord. Up to, my lord, 3 months.
3 months. Then thereafter, the next.
Now extension will
4th May.
4th May, my lord. What is the reason they have given, my lord? That I have failed to give reply.
No, not only that. Not only that. 4th May.
And that 4th May order, my lord, why they have posted on 9, my lord? They posted on 9th, my lord. But that is there's a reasonable, there's room for doubt that man they have issued in back that, my lord. When 90 days is over.
This is your allegation. Let us see their allegation. Yes, in the meantime, why don't you start the proceeding?
Look, this has come for a motion to the Lord. I'll take instructions. Kindly give me.
Start the proceeding.
Yes,
That ends there.
I'll take the.
And he's made a very specific allegation that the 4th May order has been dispatched on post that 30 days, 90 days of 6/2/2024. Will you take instructions on this?
I'll take instruction on that.
Heard Sri T.J. Mohammed and Senior Counsel assisted by Sri R. Islam for the petitioner. Full stop. The petitioner was convicted in a criminal case and pertaining to the said conviction, he was also dismissed from service. Full stop. The petitioner was holding the post of Deputy Director.
Deputy Director, Social
Welfare, NC Hills, as an in ex-cadre capacity. Full stop. The conviction, it is submitted that the conviction by the trial court was interfered with by this court in an appeal, and the petitioner has been acquitted. Full stop. The petitioner had also filed a writ petition in this court challenging the sending the dismissal, which was registered as WPC 1655 of, no, not 1655, which was registered
5365.
as WPC 5365 of 2018.
18 man.
First of the said, writ petition was allowed by judgment dated 6/2/2024 by interfering with the dismissal. Full stop. This court has, however, observed that the petitioner would continue to be under suspension for a period of 3 months from the date of the judgment, and the employer shall review the need of continuation of such suspension in accordance with the principles laid down by the Honorable Supreme Court in the case of Ajay Kumar Chaudhary versus Union of India, reported in 2015. So it is the specific case of the petitioner that though an order was passed on 26/4/2024 regarding the reinstatement of the petitioner, regarding the taking back of the petitioner in service, he was kept under suspension till a review was made. Full stop. Though a review appears to have been made on 4/5/2024, it is alleged that the communication of the review was made subsequent to expiry of 90 days from the date of the judgment. Full stop. Para. Let notice be issued, returnable by 4 weeks.
For 1.3, I'm appealing.
Sri D. Nath, the learned senior government advocate Assam, accept notice on behalf of respondent 1, 2, and 3. NCLs, Eloda, learned counsel appearing instruction on 3, RM Das, pending counsel in CHEC, for respondent 4. Let extra copies be served.
My lord, take care.
Please, Lord.
Yes, Mr. Mountain.
Lord, the petitioner before your lordship is the associate professor secretary in the Dr. Gopinath Brodley Regional Institute of Mental Health. He has been sought to be harassed like anything, and he had to come again before this honorable court, challenging this particular charge sheet, which in my school submission apparently is bogus and a vexatious one, just to trouble him. Lordship will kindly appreciate this volume itself shows of my petition that there is a secured history behind all this. I will come to it later on. Kindly come to the charge sheet itself first. What are the charges he wants to make against me? 173. Previous charge sheets have been challenged before this court. Those are stayed. And they are pending now before this court. 173 is this charge sheet memorandum dated 24th May 2024. Okay. Yes. Lord will kindly, I will take your lordship to the page 35.
Page
35. Oh, sorry, 173, annexure 35.
173.
173.
Yes.
So this is the memo. It says that he is to reply against the charges framed. Kindly come to the next page 175. Annexure 1, article of charges are there. $175, my lord. Copy of 175. This is the annexure to the memo. Copy of official documents number such and such dated 28/5/2011 has been found with Dr. Dhruva Setia, which was annexed as Annexure 1 with his WPC number such and such filed in the Honorable Guwahati High Court, filed on 29/2/2024. This official document was never issued to Dr. Dhruva Setia officially, as it indicates, and Dr. Dhruva Setia could not provide any satisfactory explanation via his reply dated 23/2024 that how he had acquired this document. Keeping or acquiring any official document, communication unauthorized.
Yes, yes, we have read. Yes, Mr. Dutta.
My lord, the petitioner challenged the so-called notice at page 11, dated 22/2. But as per the Honorable Supreme Court observation, the court under Article 226, court should not interfere with the charge sheet. And in this also, this Honorable
No, those are the very general principles. Court do not interfere with disciplinary proceeding, will be the last person to interfere. But what are the charges? That in the earlier petition he has annexed documents, which are official documents, not annexed, handed over to him. So you find him, may initiate
lord-
another proceeding.
My lord, now the petitioner challenged the document at page 73.
No, what are the charges that in the petition filed earlier, he had annexed certain documents, which are official documents, not marked to him. So you have made him and taken out an exception.
My lord,
Should you proceed against him?
he was in charge of the liability. And
No,
at the time-
today is in the age of RTI and all this. If the
Yes,
documents are
he can-
incorrect
he can-
documents, forged documents, manipulated documents, then matter would be different. Only because he has annexed the document, you find fault with him and initiate a proceeding.
Just to relating to my selection and appointment. Not
This is not,
concerning
this is
others.
not, this does not give a good message.
He's just trying.
This does not, otherwise it will be the last court to interfere at the motion stage with a disciplinary proceeding. It's your prerogative, you proceed, find him guilty, don't find him guilty, you should prove. But this charges, can they exist? Are these charges?
But the charges are specific.
What is the charge of annexing certain
173.
documents in a writ petition, which were not marked to him? You initiate a proceeding against him, you can ask for an explanation at best, and you are contesting the writ petition.
My lord, here is
Heard.
petitioner challenged the so-called notice at 1/2024 at
Yes.
page 73.
Yes,
Page 7.
173. 173.
173, not my lord, 73.
73 is not the cause of action here.
No cause of.
73 is not the cause of action here. It's 173 is the cause
It
of
is the impugn, my lord.
impugn memorandum is what date?
It is the impugn, my lord.
Page,
In this case,
page
page 73, my lord.
73.
Was the earlier purchase which was put to challenge.
That was the earlier case.
Yeah.
And my lord,
That is also success.
some requirement asked for under FR 56, my lord. 56. It is a mandatory requirement of the government, my lord, to review his periodic review of his performance, my lord. But he has moved his
Heard.
court.
Sri K.K. Mohantalan, Senior Counsel, assisted by Sri Fukan. K.K. Fukan for the petitioner. Full stop. The petitioner had approached this court earlier regarding our disciplinary proceeding, and the said writ petition WPC 2092/2024 is pending. Pending. The grievance of the petitioner is against a fresh disciplinary proceeding initiated by memorandum dated 24/5/2024. Full stop. It is submitted that the charges leveled against the petitioner cannot be termed as charges as those relate to certain documents which have been annexed in the writ petition filed by the petitioner earlier in this court. Full stop. It is submitted that the step has been taken only to harass the petitioner. Full stop. Para. Let notice be issued. Returnable by 6 weeks. Sri Iya for Mr. Ratta for Union of India.
Yes, madam.
First
My lord,
respondent.
Union of India probably,
CGC.
there is Union of India.
No, my lord, I can, my.
You can.
Well,
Okay.
Because, I have documents that from the ministry, my.
Okay, doesn't matter. For 1, 2, 3. 1, 2, and 3.
1, 2, and 3, my.
Executive Council,
1, 2, and 3. Let extra copies be served upon him by tomorrow. Let steps be taken for service of notice upon the respond numbers 4 and 5 by registered post with AD. Full stop. Para. Sri Mohanta, the London Senior Counsel, prays for an interim order. Full stop. Though a writ court, though a court exercising powers under Article 226 would normally be reluctant to stay a disciplinary proceeding, in the instant case, a bare perusal of the articles of charge annexed to the impugned memorandum dated 24/5/2024 would show that the charges are related to filing of certain documents in the earlier writ petition filed by the petitioner.
and
With full stop, the allegation has been made that those are official documents which were never issued to the petitioner. Full stop. Prima facie, this court is of the opinion that prima facie, this court is of the opinion that an issue would arise whether the same can be construed as a charge even. Full stop. Para. In view of the above, till the returnable date, further proceedings of the disciplinary proceeding, further proceedings of the proceedings initiated by the memorandum dated 24/5/2024 is suspended.
declare.
You take steps by tomorrow, Mr. Fukan. There are 2 private respondents, and give copies to Mr. Dr. Extra copies. He has to get instructions.
Please, your lordship, madam. Here the petitioners, the BCM bill clerk from meter reader in APDCL, malo. Now the problem is that their seniority has been wrongly assigned in the final seniority list at page 69, malo. They filed one representation 18/5/2022, page 65, malo. Against the provisional seniority list, malo, page 65. that representation they have stated that since their selection was on the basis of the same advertisement and their first exam was, my lord, examination, the consolidated examination held on 8/1/2012 was cancelled in respect of Rongia and Borpeta due to leakage of some question paper and all, my lord. Now page 65, that is the representation, my lord, there, so far these two circles are concerned, their written state was held on 23/9/2012 and thereby they have issued two select lists. Now, these petitioner were bona fide believe that their, my lord, so far at the time of, my lord, calculating the seniority, they shall be placed correctly as per rule 20. Page 94 is the rule, my lord.
Yes, Mr. Pathak?
The combined select seniority, they were claiming.
Kindly have a look at page number 68.
68.
68. Yes.
Yes.
This is an order which was in their knowledge, Your Lordship. This was passed on 17th of August 2022.
Calling for objections.
Yes, and the objections were decided against them. What was held was that there was a selection process where, due to certain infirmities, their appointments orders were issued later. And the rules say that the seniority will be as per the merit list. So the people who were there in the original list, their seniority was higher. Since they were appointed later, joined later, their seniority was lower. Now, objections were filed by them. That those objections were decided on 17th of August 2022. Now, without challenging that order, he has now challenged the promotion order in 2024.
No, this is under challenge, my lord. Page 68
No,
is
I'm
under
saying
challenge.
it is under challenge now, Your Lord.
Yeah, para 10 I have
And
clarified.
he has stated at page
Para 10.
number 8 that this is an order which was under his knowledge. And this order was always, he knew about it.
Yes.
He has never challenged this order.
Okay. Third, Sri B.K. Das, Learned Counsel for the petitioners. Full stop. The petitioners are aggrieved by the final seniority list of bill clerk cum meter reader
My lord, my lord.
dated 23/9/2022 and the subsequent promotions made
BCMR grade 1, my lord.
made to the post of BC/MR grade 1 on 27/12/2022.
My lord.
Full stop. It is submitted that due to some anomalies in the select list, comma, the petitioners had to join at a belated period,
My lord.
for which they were not to be fault, for which they were not at fault. Full stop. Para, let notice be issued. Sri Pathak, KP Pathak, Learned Standing Counsel, APDCL, however, submits that the provisional gradation list was published on 30/4/2022, to which the petitioners had filed objection, and such objections were disposed of on 17/8/2022, and after a long gap, the instant petition has been filed. Full stop. Para. Let notice be issued, returnable by 6 weeks. Sri Pathak,
For 1, 2, 3, and 4.
Learned Standing Counsel accepts notice on behalf of respondents 1, 2, 3, and 4. Let extra copies by tomorrow. Steps for service of notice upon the respondent numbers 5 to 33.
Yes.
Be taken by registered post with AD. Steps within 3 steps within a week.
One observer, I pray, my lord. So for the promotion made annexer 11, page 99, may be subject to outcome of the repetition.
That is the
Because
subject
otherwise
matter.
it will be problem, my lord.
That is the subject matter of challenge.
Any observation can be, my lord.
That is the challenge.
Yes.
If you are
Yes.
successful, there's promotions will
My
go.
I made them party, my lord.
Yes.
Oblige.
Item 24.
Yes.
Lordship, this is the matter is that my lord, the petitioner has filed an appeal against the measure of LNP.
PNB, there's a standing counsel, I think, Mr. Ganguly. E. Ganguly, please inform him and come at 2 o'clock. If you come at the first half, no problem.
Okay.
A. Ganguly and I think one more PNB. PNB Ganguly. no? After a while. I think 25.
May I please, your lordship? Present petitioner, a Gaura of
Yes.
yes, lordship, he was a Gaura of Puragaon, search number 12. And a case was registered against him. And subsequently he
Criminal
was
case?
arrested, lordship,
Criminal case.
lordship,
Criminal case arrested.
lordship. And subsequently he was on bail, and in the meantime he was suspended, and the case was proceed, and the victim, that is PW1, was given statement that he was innocent, and subsequently the case was proceeded, and the case was finalized, acquitting him, lordship. And
Acquitted.
that is the at page 20. Acquittal order is at page.
In the criminal case, you were acquitted.
Acquittal, lordship.
Thereafter, what happened?
Lordship, thereafter I submitted a representation before the district commissioner, and nothing has been that notification. Nothing
Of
has
appeal. Filing appeal
Lordship, appeal.
against suspension order.
Even suspension and dismissal
It may have-
and appointment also.
No, no,
That
no.
is the 162(3), Lord.
When do you file an appeal?
Lordship.
Why don't you file an appeal?
Appeal on 3/6/2024, Lordship.
You had filed.
Lordship.
Page,
Since it is pending,
page,
page 30, Lordship.
page 0. Appeal before whom?
Deputy Commissioner, Lordship.
How can it be?
District Commissioner. And he suspended me, and so considering that ground, he is the competent authority, so I made an appeal before him, and nothing has been done. In this
Appeal
case.
is not before the deputy commissioner. He is the appointing authority. You have to go with the divisional commissioner.
Lordship, he suspended me, Lordship.
Suspension, it is only a representation. If you constitute to be an appeal, it has to be before the appellate authority. Appellate authority has been identified in the rules. It is the divisional commissioner.
Division commissioner is no more, Lord.
And then the directorate.
Director of land record.
That is also changed, yes.
There is the order, that notification dated 1/2/2020.
You have passed a number of orders, you are there.
Lordship, Lord.
You file an appeal before the appropriate authority.
Lordship.
If you are aggrieved, we will grant you liberty. Okay.
Lordship.
You are SLE.
S. Hussain, Lordship.
S. Hussain. Heard Sri S. Hussain, learned counsel for the petitioner. Also heard Sri R. Dhar, learned state counsel, and Sri J. Handik, learned standing counsel, revenue department. Full stop. The considering the facts and circumstances and the nature of relief prayed for, comma, the instant writ petition is disposed of at the motion or admission stage. Motion stage itself, full stop, para. As per the facts projected, comma, the petitioner was appointed as a Gaunbura on 17/12/2012 of the charge number 12, Puragaon, village Puragaon,
Lord.
under Khariza Bizni Moza in the district in the district of Borpeta.
Bornagar revenue Saka.
Borpeta revenue second in the district of Borpeta.
Borpeta.
Full stop. He was implicated in a criminal case wherein he was granted bail, and in connection thereto, his services were placed under suspension. Full stop. Subsequently, the petitioner was acquitted in the criminal case, and thereafter he had submitted an appeal on 3/6/2024, which has not been disposed of. Full stop para. The learned counsel accordingly prays for an appropriate direction, either to reinstate him or to direct the appellate authority to consider and dispose of the appeal. Full stop para. 3. Handic, the learned counsel, learned standing counsel, by referring to Annexure 6 of the writ petition, has contended that a bare look at the said annexure, which has been constated to be an appeal, would show that the same was addressed to the Deputy Commissioner Barpeta, which is not the appellate authority. Full stop. By drawing the attention of this court to the notification dated 10 April 2018, by which amendment was done to the Assam Land Revenue Regulation 1886, reference has been made to instruction number 162C, whereby the appellate authority has been, however, the appellate power has been vested, where the power of the appellate authority has been vested with the divisional commissioner, which has to be done within 60 days. Full stop. This court has also been informed that vide a subsequent notification dated
1/2/2024.
1/2/2024, there is a change in the appellate authority, and presently the Director of Land Records is the appellate authority. Full stop. Para. In view of the aforesaid position of law, this court is of the opinion that since an appellate forum is available, the petitioner should exhaust his remedies in the before the said authority. Full stop. The communication 3/6/2024 addressed to the Deputy Commissioner Barpeta cannot be construed to be an appeal under the law. Full stop. Accordingly, the writ petition is dismissed, however, at liberty to the petitioner to file an appeal in the proper before the appellate authority as provided by law and indicated in this order. Full stop. The petitioner may also cite grounds for condonation of the delay in view of the pendency, in view of the filing of the present case, which would be considered by the appellate authority. 60 days is the limitation. You are late. You cite some grounds. An appeal will be decided on merits. Okay, next.
Apply.
May I please, Your Lord? When this case took the petitioner two grievance notice, one is the respondent has not released his salary after March 2021. Second, he was transferred from Behale to Market, and thereafter he was not allow him to join his earlier posting. Lord.
I received the instruction, Lordship. The instruction clearly says that his last certificate was issued in April 2021. Thereafter, he was transferred to Institute of Margareta. Thereafter, he has not joined there. No one knows where he is. He's not attended the office.
After transfer order was released, prior to join this order, the Deputy Commissioner of Vishwanath Tarali kindly page 38.
38.
He was engaged in election, assembly election of 2021.
21.
Page 38. Page Annexure 6.
Yes. Elections were held when?
2021.
Thereafter, what happened?
Thereafter, till he was engaged in the assembly election 8/3/2021 and till date of 29/10/2021. He was engaged in election duty. That
Till
is
29/10.
29/10/2021.
Elections were held when?
Election, he was appointed in BLO supervisor on 3/8/2021. That is the page 38. This is the order.
Training was on 12/3. Thereafter,
He was subsequently he was appointed freshly. That is page 43, Lordship. On 26 July 2021. With the reference to the above, the insurance, the smooth functioning of the ongoing COVID-19 vaccines program, I am included with the prescribed format and request submit up to date report for request to polling station was. That is thereafter, Lordship, kindly see the page 45, Lordship. He was in charge in Vishwanath 76 Vishwanath LSC, Lordship. That is 45 Swapnam Borua, BLO supervision. That is 5/10/2021. Thereafter, Lordship, kindly see page 46, Lordship.
3/8/21.
Page 46, Lordship.
3/8/2021. Thereafter, what happened?
So kindly see page 46, Lordship.
Yes.
Polling station wise vaccination status, name, number and name of
Okay, this
LSC.
is 21. Now what has happened thereafter?
Thereafter, he was his appointment was increased, Lordship. Thereafter, kindly see page he has submitted application before the election officer, and thereafter election officer forwarded letter to the deputy superintendent of access. That is page 57. Kindly see, Lordship.
57.
57.
Yes.
Married, Lordship.
No,
That is
these are all of 2021.
21, Lordship.
Thereafter, what happened?
Thereafter, he after release from the said post election duty, Lordship, he is submitted his joining letter before the by earlier transfer order. That is page 64, Lordship.
64.
Lordship.
Yes, please. Margarita, joining
Okay.
report.
Thereafter, when he submit his joining letter, they are not allowed to accept
There is no
the
endorsement here, Lordship. Yes, John, there is no endorsement here. Not from the authorities, Lordship. Even yesterday, we took instruction from the deputy superintendent excise, even from the superintendent excise, they said this person has not come to duty or has joined the office till yet, Lordship.
They are not accepted, Lordship. When I submitted, they are not.
And further, his prayer is to reinstate him in service. Reinstate him with regard to what? His prayer is to reinstate him in service.
Okay, let us see your pleadings.
Lordship.
Where have you stated that you are not allowed to join?
The petition, that is page 10, para 13, Lordship.
Yes.
Yes, submitted joining report on 31/5 before the deputy superintendent of access Margarita in the district of Tennessee by governor order number so dated so.
Now, where is the statement that you are not allowed to join or you are not allowed to discharge your duties?
The petitioner is approved the respondent of several but it is advised to mention the no step taken by the respondent till the registered.
Mr. Counsel will be in difficulty.
That is page 12, Lordship.
Will be in difficulty. Your statement you have verified as per records. You joined there. Is it a part of record?
Lordship.
Is it from some document that you have come to know that you have joined there? It's your personal knowledge. How have you verified paragraph 13?
But he was a duty election duty.
That is till 2021. Let us assume that what you have stated is correct till 21. Last December you were engaged with election duties.
Yeah.
Thereafter, where is your statement that you had gone there to join, you are not allowed to join? Your joining report does not have any endorsement. Will issue notice at this stage.
Here,
Advise your client to go there instead of coming to the court.
but he was thereafter after March 2021, Lordship, he will receive the last salary after March.
If you fail to join in your duties, where will you get the salaries from?
He was duty in 2000 up to 10 to 2021, Lordship.
Let us see.
He was election that day. That period.
You file an affidavit. You file an
That
affidavit.
period he get the salary, Lordship. He's in
And he's
duty,
asking
Lordship.
for arrears salary from the Biswanath Charlie division, whereby the LPC was issued by the last pay salary issued by the Biswanath Charlie, and he was released from there.
What is my fault? They are engaging.
He's not joining there. No one knows where he is.
Be Islam. Heard Sri Be Islam Learned Counsel for the petitioner. Full stop. It is the case of the petitioner that he was serving as an assistant inspector of excise at Biswanath.
Bihali.
At Bihali in the district of Sunitpur. And wide and order dated and wide and order dated 9 to 2021. He was transferred to Margherita in the district of Tinsukia. Full stop. The petitioner has admitted that he was released from the said post at Behali on 15 to 2021. Full stop. The petitioner has, however, submitted that in spite of such release, he was engaged with election duties.
Lordship. 2021 assembly.
However, his salaries have not been paid from
After March 2021.
From March 2021. Full stop. Para. Sri R. Gogoi, Learned Standing Counsel, Excise Department has, however, submitted that the petitioner was given salaries up to March 2021 and was admittedly released to enable him to join the post at Margherita. And as per the records, the petitioner never joined in his new place of posting. Para. Let notice be issued, returnable on 21st of August. Mr. Gogoi for 1, 2.
1, 2, 3, 5, and 6.
4, not 4.
Top 4.
1, 2, 3, 5, 6. Election officer. D. Bora 4. Treasury. Any finance department? Standing Counsel Finance Department. Pinayak. Chalia was there. Pinayak, Standing Counsel Finance Department for respond number 7 and 8. Let extra copies be served within 2 days. Okay.
No, sir.
Item 24.
My lord, in this case, my lord, BK Sen is the newly appointed standing counsel, my lord. But today he is not well. I have
Who is this?
BK Sen.
BK Sen.
BK Sen. His chamber is in Polton Bazaar, my lord.
PNB BK Sen.
Punjab and National Bank, my lord.
Is it a standing counsel or a panel?
Yes, standing counsel. My lord.
Okay, then we'll have it on Friday.
Yes.
Friday?
Friday.
You please inform him.
Already, my lord, we have discussed the matter, my lord. He is not well on today, my lord. He's
No,
sick, my lord.
Friday.
Friday, my lord.
That is it. Those three D. Barua. learned counsel for the petitioner is present, comma, standing counsel PNB is not present, full stop. Sri Barua has however submitted that the standing counsel is having some personal difficulties today, full stop para. In the interest of justice, list for motion on Friday.
Right. Well, if it is possible, his name may be shown at the BK Sen in the cause list.
SC PNB is there, let him come.
Obliged.
55.
May I please, Lord? My lord, here once this petitioner was also promoted.
This is item.
First appointment letter at page 14. He was appointed as workers Khalasi in the year 1985.
He was appointed when?
My lord, it is dated, my lord, 10/9/1984.
10?
10/9/1984.
Appointed as what?
Workers Khalasi, my lord, with effect from, my lord, 1/9/1984.
Workers Khalasi with effect from?
1/9/1984.
1984.
84.
Doesn't
And he was promoted, page 16, my lord. It is dated 31/10/1987.
Promoted as?
He was promoted to, my lord, pump operator. Workers pump operator.
Yes.
Hereafter, my lord, GPF account, etc. was given, my lord, page 18, my lord. I have just annexed.
Page 18 is what?
GPF account he got, my lord. And, my lord, thereafter, retirement notice on 31/5/2021, page 20, annexure 4, my lord.
Page?
Page 20, my lord, retirement notice.
20.
20, my lord. And his gratuity, etc. was, my lord, calculated, page 21, annexure 5. Details, my lord, particular of his service career is given, my lord, shortly. Page 21, my lord, date of entry in service, then, my lord, date of retirement, then total length of service, breakup in service nil, my lord, net service standard 36 years, 8 months, 21 days, pay on last date, my lord, 36,570, etc., my lord. And gratuity amount is also provided.
Yes.
Page 22, my lord. Here, my lord, I have annexed, my lord, one judge order of the Honorable Supreme Court, my lord, recently passed, my lord. Here, my lord, Honorable Supreme Court, my lord, expressed, my lord, it is not proper. So, page 23, my lord.
20?
Page 23, my lord. This is a short judgment, my lord.
23.
23, my lord, Annexure 7. It is unfortunate that the state continued to take the service of the respondent as an ad hoc for 30 years, and thereafter now to contend that he as the service rendered by the respondent are ad hoc. He is not entitled to pensionary benefit. The state cannot permit to take benefit of its own wrong. To take the service continuously for 30 years and thereafter to contend that an employee who has rendered 30 years continuous service shall not be eligible for pension is nothing but unreasonable. As a welfare state, the state has such ought not to have take such a stand. In the present case, the High Court has not committed any error in directing the state to pay pensionary benefit to the respondent who has retired after rendering more than 30 years service. Only, my lord, my humble submission before your lordship, this is only technical reason, my lord. One regularization order was not issued. Otherwise, my lord, the conduct of the respondent is more than, my lord, regularization only. Salary with incremental benefit, etc., provided he was continued in service, my lord.
Where is the scale pay given to you? You said incremental benefit. Where is the scale? Was any point of time scale pay given to you?
Yes, my lord, increment. It is, my lord, actually, my lord, one open task, my lord, there was some observation of this court, my lord, to give them salary, my lord, reasonable salary, my lord. They are perhaps therefore they have given, my lord.
No, that is to give you the minimum scale
Yes, my
of
lord.
pay.
Yes, sir. But here, my lord, they got everything. Salary.
No, you are praying for what?
Pension, my lord.
Pension. Salary is a different aspect, pension is a
Yeah,
different
yeah.
aspect. So unless your services is regularized,
Yes.
you will not be given pension. So your ultimately claims boils down to the aspect of regularization of your service. Now, regularization, can it be done?
Only, my lord, as per, my lord, rule 31, my lord, there is term, my lord, regularization is not mentioned, my lord. 31 provided that, my lord, they may be appointed by the government, they must be paid by the government, they continued in the service, my lord. But the word, my lord, regularization, exactly this word is not it. But here, my lord, lordship kindly consider, my lord, on humanitarian ground, my lord, that they are
No, one
conduct.
case, can we consider one case in isolation?
No, my lord.
After open test
Recently,
has
my
been-
lord, one judgment, my lord, I was also there, my lord, this is very recent judgment, my lord. Considered everything, my lord, we were also there. Huh? Consider. This is dated on 2026.
Some others similarly situated will be considered to under pressure. In that case, Mr. Borbia?
Yes, Paul.
In that case, in paragraph 15, the court, after Upendas, has said that this single bench cannot
Yes, Paul.
bypass the
Yes, Paul.
Upendas. But at the same time, in those cases, you had got some instances of some work charge employees who were given the benefit of pension. And
Right.
those adjournments were not controverted. Under those circumstances, the direction was given for consideration. In the case, have you cited any other example that in the department, some other similarly situated persons have been given the benefit of pension? Have you?
My lord.
Now, in your case, in the writ petition, now we are deciding.
Yes, my lord.
Have you cited any example of other similarly situated persons?
My lord, example is not given.
In that case, that is the only consideration. You see, read paragraph 15. Do you have a copy of this?
Yes.
Do you have a copy of this judgment? Passed in the WPC, what, 6589? Please read paragraph 15. Paragraph 15. You have this?
Yes, sir.
Take this. I have the hard copy. It'll be easier for you. Read paragraph 15. Please read aloud. Let
Yes,
Mr.
sir. Be that as it may, a specific issue was raised before the division bench of this court in Upen, the supra as to whether master worker's employer entitled to pension. This has been negated by the judgment of the division bench of this court in Upen, thus the supra. The same is therefore binding on this court. The learned counsel for the petitioners have also raised before this court an order passed in respect of another similarly situated workers employee who have been considered to be eligible for grant of pension by the department. A copy of such order is available in this writ petition. The respondent did not file any affidavit in response to such.
Okay, we'll continue at 2 o'clock. Have a look at the judgment. And in that case, there was some specific instance that similarly placed persons were given the benefit of regularization and consequently pension. It's up to you, but the mandamus it cannot go. More so after open does. But have a look at this. And Gujarat case has been taken into consideration by
Yes,
this
yes,
case.
yes, I was there, my lord, in this judgment.
Yes, Mr. Bhattacharya.
On the 35, I would like to place the judgment of the apex court. There are lot very categorically without conditions, it has been ruled that workers employed, irrespective of duration of service, are not entitled to pay.
No, see, pension has to be in with regard to a regularized service. What Mr. Borbay is trying to contend that under section regular 31, the expression regular is not there.
But it says permanent and substantive.
Substantive post. We don't think we have any merits after Upendas and Uma Devi.
No, I'm saying just on this similar, my lord.
Which one? Now, in that case, some other orders were shown.
In that case, lordship.
Some orders were shown. Where is the orders in this case?
Here, my lord, it is regarding the same department, my lord.
Show the orders. In those cases, orders were shown.
So this is judgment is recorded, my lord, and I have, my lord, contained in the paragraph page 7, my lord, last part also, my lord.
That will not do. And for the department, it will be open, but being open also, they have to act in accordance with law.
My lord, it is word, my lord, may is used, my lord. It is
We cannot issue a mandamus. Heard. Sri A.M. Borbay, learned counsel for the
page 7, my lord, for the last part, my lord, I have stated that, my lord, other candidates are given, my lord, similarly situated. On the other hand, the other similarly situated employees are granted pension, including some junior to the petitioner.
Where? Page?
Page 7, my lord, last 3 lines.
Give the details.
Then, my lord,
If they're doing it on their own, there is no bar.
as per Upendra's, even the state government is prohibited to regularize employees
Art
without.
3 Board we are learned counsel for the petitioner. Also heard 3 I Borthakur. Learned
My lord, with all respect, my lord, I may refer, my lord, this judgment, my lord. Here it is, my lord, the judgment of this honorable court. It is recorded here that other similarly situated.
We'll record their judgment.
Yes, sir.
Give it
Only
to us.
that part, my lord, here, my lord, word, my lord, in the order, my lord, it was provided May, my lord.
You have made your submission. We have heard you.
Yes, sir.
No need to repeat it. Give it to us. I Borthakur learned standing counsel PHC. Finance department, anybody? Mr. R. Botpadari, standing counsel finance department. 3 C. Borwa, learned standing counsel AG Assam. Mr. Chaudhary, are you for anybody? No. Okay.
In fact, my lord, few days back, Lordship has pronounced a judgment like joiner and firm. That is pertaining to place it for identically covered.
Which says the grant substantial conflict are there.
As on today, well, I am not disputing, my lord, these people are not being paid, my lord, pension, my lord.
That judgment pronounced by your Lordship, my lord, squarely covered.
Okay. Okay. Considering the subject matter. And considering the subject matter, the writ petition is taken up for disposal at the motion stage itself. Full stop. Para. The claim in the writ petition is for grant of regular pension to the petitioner. Full stop. Para. As per the facts projected, the petitioner was working in the PHE department as a work charge Khalasi from 10/9/1984. Full stop. Thereafter, vide an order dated 31/10/1987, he was promoted to the post of work charge pump operator and was posted in the Hailakandi town waters supply scheme under the a supply scheme. Full stop. The petitioner had retired from service on attaining the age of superannuation on 1/6/2021. Full stop. The petitioner's grievance, as reflected above, is towards release of his pensionary benefits. Full stop. Para. 3. Bolbia, the learned counsel for the petitioner, has submitted that after his retirement, lump sum gratuity has also been paid to him. Full stop. He submits that the petitioner, having served for a long period of time since his initial date of appointment, the pension should be granted to him. Full stop. By drawing the attention of this court to Rule 31 of the Assam Service Pension Rules 1969, the learned counsel has submitted that the said provision is not restricted only for regular appointee and can be extended also for work charge employee. Full stop. It is submitted that in a similarly situated case pertaining to the same department, there is a direction of this court dated 26/2024, passed in WPC 6582 of 2023 for consideration of the case of the petitioner in that case. Full stop. Reliance has also been placed upon the case of, where is it? How to go to or it was now? Or it was Supreme Court. Where is the decision? Supreme Court? It is not Asile. Nagaratna. Did I hand it over to you? One decision of the Supreme Court?
Certified.
Huh? It was High Court. Court bulletin. One more decision you had cited of the Supreme Court?
One minute, I have annexed my page.
Oh, you have annexed?
Yes, sir, page 23.
Page?
23, minute, annexed 7.
Right. The learned counsel has also, yes, page 23, it is. Relied upon an order dated 18/2/2022 of the Honorable Supreme Court in the case of State of Gujarat versus Talsi Bhai, Dhanji Bhai Patel, wherein length of service was considered for payment of pensionary benefits. Full stop. Para. Per contra, comma. Sri Bothakur, the learned standing counsel of the department, has submitted a pension rules submitted that a claim for pension is to be preceded, but is conditional upon the fact as to whether the incumbent was a regular employee. Full stop. In the instant case, comma, it is not in dispute that all along the petitioner was on work charge basis and had retired in the same capacity. Full stop. It is submitted that in absence of any order of regularization, comma, grant of pension is not permissible in law. Full stop. As regards the applicability of Rule 31 of the Pension Rules of 1969, comma, it is submitted that the employment must be substantive and permanent, and work charge engagement cannot be held to be a substantive and permanent employment. Full stop. With regard to the case law, with regard to the earlier order of this court passed in WPC 6582 of 2023, comma, it is submitted that there was no mandamus as such, and only on certain instance where pension were granted to some employees, comma, the case of the petitioners were directed to be considered. Full stop. The learned counsel has also referred to the decisions of State of Karnataka versus Uma Devi 3 reported in so-and-so, wherein the Honorable Supreme Court has laid down the conditions which are required for regularizing the services, and those conditions are not fulfilled. by the petitioner in the instant case. Full stop. He has also submitted that the issue has been settled by the Honorable Supreme Court, by the Honorable Division Bench in the case of State of Assam versus Upendas, reported in so-and-so, wherein the claim for regularization have been negated with negated, full stop. The learned counsel has also relied upon a judgment of the Honorable Supreme Court dated 28/4/2023 in the case of Uday Pratap Thakur versus State of Bihar, in which the claim for pension has been negated as the employees therein were work charged employees and were not appointed in a substantive post. Full stop. Para. Sri Borpujari, the learned standing counsel, finance department, and Sri Barua, learned standing counsel, AG Assam, has submitted, while endorsing the views expressed on behalf of the administrative department, has submitted that a claim for pension by an work charge employee is not maintainable. Full stop. Para. The rival submissions have been duly considered. Full stop. The reliance, the petitioner has relied upon Rule 31 of the rules of 1969, which is extracted herein below. Full stop. Out of the three essential conditions to qualify oneself for pension, comma, it is provided that the employment must be substantive and permanent. Full stop. A work charge engagement cannot be held to be a permanent and substantive employment, and therefore reliance upon Rule 31 is misplaced. Full stop. The question therefore arises as to whether whether by mere length of the service rendered, comma, an incumbent would be entitled to pension. Full stop. The aforesaid issue has been conclusively settled by the Honorable Division Bench in the case of Upenda Supra. Full stop. In the said case, paragraph 8 to the yeah. Issue of regularization, Upendas, Umar David 3, then the paragraph 8 or 9, huh? The learned standing counsel of the department has also submitted a recent order passed by this court on 23/7/2024 in WPC 5820 of 2021 within bracket Joy Narayan Sharma versus State of Assam. Full stop. It is submitted that even in the said case, instances were relied upon wherein benefits of regularization were given to similarly situated persons. Full stop. However, comma, this court had observed that those orders of regularization does not appear to be in accordance with law. Full stop. In the instant case, comma, apart from making a bold BALD statement in paragraph 6 of the petition, comma, no details have been cited regarding any work charge employees being given the benefit of pension. Full stop. In any case, comma, this court in the order relied upon by the petitioner had only made an observation that the department may consider the case of the petitioner, and there was no mandamus as such. Full stop. Better. In view of the aforesaid facts and circumstances, comma, this court is of the opinion that no relief can be granted to the petitioner in the instant case, and accordingly, the writ petition is dismissed. Okay. Yes, next. 13 timing.
Obligable.
Yours is 30 or what?
I have given a copy, man. I have given copy.
Yes, yes. What was this?
But yes, in the online application form, my lord, against the column ex-serviceman category,
Okay, okay.
yes was mentioned, my lord, and therefore I was not allowed to join. Otherwise, I have been appointed.
You belong to SC category.
I belong to SC.
Did you apply as SC?
SC.
But you are not ex-serviceman.
No, my lord. That was my lord duty inadvertence, my lord. And I got the application form filled up through employee of the.
Mr. Chaudhary, you need to take instruction that irrespective of the option indicated by the petitioner, assuming that it was an erroneous indication that he doesn't belong to, which he is saying, that then in that case, would he qualify to be appointed as an SC candidate?
Because the the system is such that against the grade pay and the qualification, there is a software lawsuit. It places the person who have qualified in the who have applied, places the person in the
No, that we understand, but ultimately depends on the marks. Treating him or her, treating him to be a SC candidate who doesn't belong to the ex-serviceman category, would he come within the zone of consideration? That instructions you can take. Well, issue a short notice. Okay. Third, C3F AFNU Mullah, Learned Counsel for the petitioner. Full stop. It is the case of the petitioner that in a recruitment process for appointment of grade 4 via an advertisement dated 25/3/2022, the petitioner had applied online under the SC category. Full stop. However, SC category. However, by mistake, in the column meant for ex-serviceman, the petitioner had indicated in the affirmative. Full stop. In the recruitment, the petitioner was selected for appointment via an order dated 23/5/2023. Full stop. However, the petitioner was not allowed to join on the aforesaid ground. Full stop. Let notice be issued. Returnable on 21st of August. 21st of August. 3. 24.
I pay for 125.
D. Bora London State Council accepts notice on behalf of respondents 1, 2, and 5. Whereas 3. B. Chaudhary, London Standing Council SLRC accepts notice on behalf of respondents 3 and 4. Let extra copies of the writ petition be served upon the learned counsel for the respondents by within 2 days.
Maybe Sony.
Registry to reflect the name of Sri B. Chaudhary, Standing Counsel, SLREC, huh?
Pendency may not be party found otherwise fit.
Let me have that.
Have the instructions.
Obliged, but
Obliged.
Item 28.
May it please. This is for non-payment of the subsistence allowances. The petitioner was last occasion, instruction was not for.
My instruction says up to 2015 it has been paid.
Up to 2015.
It has been paid.
Thereafter,
Up to 18 it has been sanctioned that you will can say whether he is paid or not. We have sanctioned.
no, he's.
Up to 2015.
Oh, this was instituted in 2020.
Well,
This was instituted in 2020. 2020.
2020.
Now, what is the instructions latest? Have you got the latest?
Latest instruction, up to 2015 they have paid. And subsequently, not a single penny.
No, payment till 2015 will not do because you had filed in 2020. So
Yes.
after 2020, is anything paid? Not paid.
No.
Yes, yes.
Up to 2000, we have filed our affidavit. Up to 2018 it has been sanctioned.
No, sanctioning will not do.
Yes.
You have to pay the subsistence allowance. Finish up with the proceedings. Why do you suspend and unnecessary pay 75% without utilizing the service?
Even minor earlier release pursuant to this honorable court. Kindly peruse the page 34. Page 34, a relevant portion, page 34.
Yes. Sir.
I'm praying for the disposal of this
2020 matter.
of this petition with a direction to release the.
Okay, we'll have it on today is what? Wednesday. We'll have it on Wednesday next. Get the instructions.
Yes.
Heard Sri R. Islam Learned Counsel for the petitioner. Para. Sri S.S. Roy Learned State Counsel, who was given time to obtain instructions, has submitted that subsistence allowance till the year 2015 has been paid. Full stop. The same has also been sanctioned for the period 2015 to 2018. Full stop. The writ petition has been filed in the year 2020, and payment of subsistence allowance cannot be denied when an employee is put under suspension. Full stop. Para. Sri Sharma, Learned Standing Counsel, NHAC, NCHAC, prays for and is granted a week's time to obtain instructions. Full stop. List on Wednesday next.
WhatsApp.
Mr. Roy, you can take this back. You can phone the diva, no? Very good.
Lordship, PQ has been issued way back in February, Lordship.
Just I have come to know, my lord, just now I have come to know on to regular pension he has received, my lord. As PP already issued, my lord, so possibly he will get.
As per the last order, the matter pertains to a claim for pension. Full
After
stop.
rectification of the date of birth.
Pension. The petitioner, who was a regularized master roll employee,
yes,
had gone on superannuation on 31/12/2019, and this writ petition was instituted in the year 2023.
Yes.
Full stop. Para. On the last occasion, that is 17/7/2024, comma, the Learned Standing Counsel, AG Sri B. Chakraborty, was directed to obtain instructions. Full stop. Para. Sri Chakraborty, as per instructions, has submitted that the PPO has already been issued, and this fact is confirmed by Sri H. Das, Learned Counsel for the petitioner. Para, in view of the aforesaid development, comma. Oh, no, nothing like that. Sri Chakraborty has also forwarded the relevant communication of forwarding the PPO and the connected document relating to the calculation, relating to DCRG. What's the para? In view of the above development, comma, there is no requirement to proceed any further with this writ petition, and accordingly the same is closed. The documents handed over, placed on the document placed before this court regarding the PPO are made part of the records. You are for
1, 2, and 4, Lord.
Anupadhyay, Education Department. Okay.
Obliged.
May I please, Lordship? Lordship, I have a very limited prayer, Lordship.
Why do you have a limited prayer? Your prayer should be unlimited.
Lordship,
If you are limiting your prayer, what can we grant? We will not be able to grant you anything.
Lordship, the petitioner is a widow of 76 years old lady, Lordship. Her son was the only, she was totally dependent on her son. Thus, her son was missing in 2020. He was working in this Lordship. After his missing,
He was working where?
SSB Lordship, as an ex-HDGD.
Sasastra?
Seema Ball.
What is the difference between Sasastra Sima Bal and Sima Suraksha Bal?
I have no idea, Lord.
No idea. Not same. Same.
No, Lord.
Not same.
I think not same, Lord.
When was Sasastra Sima Bal? When was it thought about? When did it come to light, this particular organization? What was the factor? What ignited? No idea.
I'm sorry, Lordship, I have no idea.
You should know. We have not asked you. Did you ask you? Okay, what happened? Your son was working there.
He was working there. He was missing from 2020.
While in service.
Lordship.
Then
His wife get the pensionary benefit, Lordship.
your daughter-in-law.
Lordship.
Okay.
He has one son and one daughter, Lordship. So she is getting the pension from 21 to 2020, Lordship.
Petitioner is the mother.
Mother of the
And the employee has his wife and two children.
2 children, Lordship.
Yes. Now, what is your grievance?
Lordship, I don't have any source of income.
You are
Petitioner
dependent.
is dependent on him, Lordship. But the authority has granted full pension to the wife, Lordship. And she is a very old lady. Now she is
Yes.
bedridden,
You are
Lordship.
for you are for the wife.
Wife, Lordship.
Wife of the employee. The copy will be this is coming for the first time, madam.
No, Lordship. We have taken the steps and service
Oh,
is
you have-
completed.
Mr. Ahmed, you are appearing for the respondent number 3. Respondent number 3. But otherwise also you need to. it's- No, but how do you deny the widow mother? No, now since she has come to the court, you know that there is a mother
Lordship, there is a full.
dependent on the son.
Please, I got captain not press market.
Did you write to them?
Lordship.
Where is your?
Lordship, may kindly see.
Replied in page 20.
Madam, you may not, they may not be at fault because they do not know that the mother was there.
Her name was mentioned.
Wife's name, only the wife's name.
But we have, in the state, we have praname. But like the
No,
second
what is your objection to this?
I have no copy of the petition, my lord. I may.
No, you have been instructed to appear. You know the subject, irrespective of whether you have the petition or not.
I am
What is
the
your
wife-
objection?
I am the wife of the.
No,
Yes,
mother is
person.
also entitled.
My father is not.
Not entitled. Under what law? Dependent mother is not entitled.
Which mother is entitled actually.
Then actually if he's entitled, then if he's not actually entitled, then why don't you settle the matter? Why should she come to the court? Sit down and settle the matter.
If the mother is found something, my lord, I have no.
Parties are Hindus or Mohammedan?
Hindus, Lordship. There is a full bench judgment also, Lordship, where it says that.
And if they are Hindus, then mother's right is there. You sit down and settle. We grant you some time, take instructions, but advise your client to settle the matter.
in one case, Supreme Court held pension is a property that has to be inherited by.
Paragraph 22 and 23.
Madam Bopujar, we grant some time to,
Okay, Lordship.
since he's appearing for the first time. Okay. Third, Miss D. Borpujari, learned counsel for the present. What's up? The matter pertains to a claim for apportionment of the family pension,
Lordship.
which is payable under
Mhm.
SR 10 capital A within bracket small a of Rule 54 of the CCS pension within bracket rules 1972. Full stop. The petitioner claims to be the mother, dependent mother of the employee who had gone missing in the year 2020, and the family pension is being paid to her daughter-in-law only, who is impleaded as respondent number 3.
Lordship.
Full stop. Your A.N. Ahmed.
Yeah.
Sri A.N. Ahmed has entered appearance for the said respondent number 3 and has paid for some time to obtain instructions. Full stop para. Let this matter be listed. We'll fix a date, family pension. On 16th of August 2024. Para, pendency shall not be a bar to amicably settle this matter outside the court.
Much obliged, Lordship.
What is this, madam?
This is the full court judgment, Lordship.
Oh, yes, we have to file maintenance. This is why are you bringing this? Not applicable. Second wife can file maintenance against the first wife. How is it applicable?
No, in this case,
Yes, next.
May it pleases your lordship. These two matters, my lord, are covered by the decision of the Upenda's case, my lord. The page 16 is the order. This would be the respondent number 6, my lord. That the petitioner was engaged as works 2/1/1999. My lord, somewhere the date has been wrongly given. Somewhere 1991, page 16, my lord.
Yes.
Engagement of grade 4 employee Sukumar Bosumatari with reference to the subjects that I have the honor to inform that the office of the undersigned, the Sukumar Bosumatari grade 4 wage basis engaged in various rate remuneration in the part-time and full-time basis. He is working this establishment with effect from 2/1/1999. My lord, now my lord, my prayer is that, my lord, that pursuant to the Upenda's case, I have given that the judgment page 20. and there is an office notification issued page 28. Well, they have given the benefit out of the offender's case, fixed pay remuneration of 15,900. To such employee, if regulation cannot be made. Now, my lord, page 28 is that, my lord, notification.
Yes.
My prayer is that, my lord, I should be covered up by this notification, lordship. And now he is getting, my lord, page 32, 3,000 only. Right side, second column, my lord, fixed pay 3,000.
32.
32, my lord. Of course, my lord, here initial date of joining has been wrongly shown. It should be 1999. It is saying 1991. It should be 1999, my lord, as per that later, my lord.
Yes, Mr. Nayak, not
Covered, my
in
lord.
the, not covered in the offenders.
The lordship, so far as first case is concerned, lordship, Sukumar Bhattumotari, the lordship will come to page 16, lordship.
16 years.
He was engaged as sweeper, lordship.
Yes.
Now, lordship, sweeper post are two types, lordship, one part-time and one full-time basis. Page annexure 3, page 16. With reference to the subject cited above, I have the honor to inform you that the office of the undersigned engaged Sri Sukumar Bhattumotari as the grade 4 wage basis engagement in various rates of remuneration in part-time and full-time basis. He is working this under this establishment with effect from 2/1/1999 till date. Now, the previous page, lordship, in the previous page,
15.
15, page 15, first paragraph, last two lines. Sri Sukumar Bhattumotari upgraded full-time working duties with effect from 1/4/2010. So earlier, lordship, he was
From the date of judgment of offenders, it's not 10 years.
No.
not 10 years. That is one. But so far as second case is concerned, lordship, it appeared.
I will clarify page 15, my lord. Earlier, he was getting 300. My lord, keep line lordship seen 300 per month. And after this order, my lord, with 2010, he has been given 3,000. Now he is getting 3,000 as I was shown page 32, my lord.
But why is the last line then?
My lord.
Why is the last line in page 15?
So
the duty of the office peer, office cleaner.
Grade 4 West basis Sukumar was upgraded full-time working duties with effect from 1/4/2010. But my lord, if that be so, if my lord, then his remuneration has not been given as per the notification, my lord. That notification issued pursuant to Upenda because from 1999 up to Upenda's case 2017, he has completed 18 years, my lord.
No, 1999, you were in the part-time capacity, not even work charge.
Yes, ma'am.
Here, Upendas only deals with work charge employees who are
works as casual and master role.
Casual, yes, but here is the part-time.
My lord.
So for a second case is concerned, there is no problem, difficulty, but first case.
But my lord, in my humble teaser, my lord, because my lord, there, para 22, page 26, my lord, of the judgment, it is however heartening to learn that the state.
No, that is the concession of the state.
Yes.
Paragraph 22 you are reading.
From that is the they have given a concession to such to these employees that works as master rule.
But since last more than 10 years, that is the condition precedent.
That's correct.
Not to
all. From 2000.
Master role, work charge, and similarly placed employees. Here is a part-time worker.
My lord. From my lord,
your full-time became only in the year 2010, and Upendas was
upgraded full-time working duties.
Was decided on 8/6/2017.
Yes, 7. My lord, because all the communications are there, the office they have, my lord, communicated, my lord,
yes,
continuously. Lordship, see, my lord.
Part-time, okay, but can something be done? because the
let them
intention
consider,
was
my
to
lord.
give them.
Lordship will dispose of this matter, directing the authority to verify and
Verify and consider on the basis of the notification.
without.
No, you are correct. At part-time, there's a difference, but the intention of Upendas was that we cannot
Give some
grant you
benefit.
regularization, but at least minimum pay. And
Right.
minimum pay, you have taken a conscious decision to give that notification. And the second one, there is no problem.
Yes.
Second one of Lord, at page 14.
Page 14,
Yes, Lord.
10 years not over,
He was also engaged as part-time.
part-time.
With effect from
Okay, you consider.
1/3/2000.
Okay, both are similar.
Yes, sir. But here, my lord, engagement, my lord, 1/3/2000.
In the first case, Lordship, at least one upgradation is there. In the
Mhm.
second case, that is also not there. At least from the reading.
First case, what? 1-3? First case.
First case. Page 15, my lord.
3923.
10-3-1999.
My,
Initial date.
first case, my lord, initial opponent, page 16, 2/1/1999, my lord.
2-1-1999.
And upgraded to full time working duties, my lord, with effect from
1/4.
1/4/2010, my lord. And my lord, page 31, their officer, my lord, they requested the, my lord, additional director for regulation of the service, page 31, along with the
31.
data. Page 30.
And where is that notification after Upandas?
That notification, my lord, just page 28. In suppression of earlier fines, notification of the following are hereby notified. Compliance by all state government department as applicable for the master role, works as casual and similarly placed, my lord. Third line of page 28, my lord. Employees who were engaged prior to FRBM period with effect from 1st of September 2005. The fixed wage remuneration will be 15,900, with dearness allowance will be admissible, which will undergo revision whenever pay scale specific.
Heard Sri B.K. Das, learned counsel for the petitioner. Also heard Sri R. Dhar, learned state counsel, and Sri P. Nayak, learned standing counsel, finance department. Para. Considering the subject matter in dispute and as agreed to by the learned counsel for the parties, the writ petition is taken up for disposal at the admission stage. Full stop, para. As per the facts projected in the writ petition, the petitioner was engaged as a master role worker in the office of the project director, integrated tribal development project, Gosaigaon, on 1/2/1991.
But that is the wrong, my lord. 2/1/1999 in Sutima, sorry, but as per page 16, my lord. 2/1/1999.
On 2/1/1999. Full stop. The petitioner's services were upgraded to full-time on 1/4/2010. Full stop. The claim of the petitioner is based on a notification of the Finance Department dated 3/10/2019, as per which fixed pay public remuneration with dearness allowance was held to be admissible with regular, now with revision of pay as per the judgment rendered by the Honorable Division Bench in the case of State of Assam versus Upendas, delivered on 31/8/2017. Full stop. In the said case of Upendas Supra, while the claim for regularization of service by work charge, master role and casual workers was negated, minimum scale of pay was directed to be given to them. Full stop. Para. Sri Das, the learned counsel for the petitioner, has submitted that his initial date, submitted that the date of the initial appointment being 2/1/1999 and 1999, the petitioner meets the requirement of getting the benefit of minimum pay scale as laid down in paragraph 22,
as well as the notebook.
22 of in the case of Upendas. Full stop. It is submitted that the petitioner has completed more than 10 years as on the date of passing of the judgment of Upendas. Full stop. Para. Sri Nayak, the learned Standing Council Finance Department, has however pointed out that the case of Upendas, so far as the benefits of minimum pay scale is concerned, along with certain other benefits pertains to master role, work charge, and similarly placed employees.
Correct.
Full stop. He submits that the petitioner was initially appointed as a part-time, on a part-time basis, and only from 1/4/2010, his services was upgraded to full-time. Full stop. He submits that the period of 10 years has to be reckoned from the date when such upgradation was made, as part-time service would not come under the notification dated 3/10/2019. Full stop. Para. Sridhar, the London State Council, endorses the submission of Sri Nayak. Full stop. Para. The petitioner was admittedly appointed initially on 2/1/1999, which however was on part-time basis at a fixed salary of rupees 300 per month. Full stop. He was however upgraded to full-time basis with effect from 1/4/2010. Full stop. The petitioner has been presently getting a fixed pay of rupees 3,000 per month. Full stop. The notification dated 3/10/2019 issued pursuant to the direction of the Honorable Division Bench in Upendas Supra contemplates a fixed wage / remuneration of rupees 15,900 with ancillary benefits of enhancements along with medical allowance of rupees 600 per month. Full stop. At this stage, comma, it would be relevant to refer to the observations made by the Honorable Division Bench in the case of Upendas. Full stop. Paragraph 22. Full stop. The aforesaid observation / direction made by the Honorable Division Bench was on a concession made by the state. Full stop. The intention, the claim for regularization, which was rejected, comma, the state has expressed that some benefits would be given to the master role, work charge, and similarly placed employees regarding the pay and ancillary benefits. Full stop. In the instant case, comma, the initial induction of the petitioner in service was on 2/1/1999. Full stop. Though, if the date of upgradation of his service to full time, which is 1/4/2010, is taken into consideration, comma, the petitioner would not fulfill the requirement of completing 10 years with effect from 1/8/2017 as held by the as laid down in the case of Upendas. Full stop. However, the intention of the Honorable Court, while rejecting the claim for regularization, was to give certain benefits so far as the minimum of pay scale is concerned. Full stop. The use of the expression similarly placed employees would indicate that even a part-time employee who was continuously working for a period of more than 10 years, as on 1/8/2017, is to be given such benefits. Full stop. In any case, comma, the state government in the finance department had issued the notification on 3rd of October 2019 to give such benefits. Full stop. Depriving the petitioner from such benefit on the only ground that his initial appointment was on part-time basis may not be fair. Full stop. In that view of the matter, comma, it is directed that the benefit of the notification dated 3/10/2019, which was issued as per the direction of this court in Upendas Supra, is to be given to the petitioner. Full stop. The full stop. Such benefit would accrue from the date when the benefits were given to the other master role and work charge employees. Full stop. Petition accordingly stands allowed. In the next part-time.
My lord, part-time.
Date.
My lord, your part-time dated, my lord, is 1/3/2000, my lord. Page 14.
1/3/2000.
Yes.
And upgradation same date.
Mala upgradation here is not upgradation. Mala he is continuing as the mala
part-time.
Part-time.
Upgradation নালাগে না আৰু 1/3/2000 হ'ব এটো
Page 14
এইটো part-time suitably চেৰি কৰিম ঠিক আছে Say, is it the same department?
It is additional director comes is the BTC is there, my lord. Same department, yes.
Okay. Who is BTC a party here?
Joint secretary. Yes, respondent number C.
Then Nayak for BTC.
kindly record A Solia's name for finance.
Okay, that will be better. তেনেহলে হেৰি কৰিব submission to HOLIHAR. Is he in the court otherwise? Okay. Submission to হেৰি কৰিব HOLIHAR কৰি দিব financial.
Difficulty for.
No, not difficulty. These are welfare measures.
Not if all the seasonal workers will come into the purview of the.
Seasonal is not continuous. How is seasonal part-time? Part-time is different. It has to be continuous service 10 years.
Taking service.
Seasonal is for some time, then again discontinuation. They will not create it. These are welfare measures.
Yes.
Do some benefit to the public.
Deeply obliged.
Otherwise also we have considered.
No, see, your apprehension may be correct. Seasonal workers, but it's the seasonal workers will not come within part-time.
Obliged.
We have to recon whether it is a continuous service.
Continuous. From 99.
Part-time, pilot.
No, it is taking
Some-
continuous.
Yeah, they maybe it's a pilot.
Part-time is not, part-time is
Daily-
not without break. Part-time is a working hours are less, but it is a continuous service.
Some pilot, that's a person, they have 3 part-time jobs in it. I think 3.
You are not required to pay 3 times the minimum wage. Only
No,
one
one
time.
time.
Part-time, he's a part-time. Then that was for pilot.
Therefore, consideration should be more for the part.
What is
Obliged.
your age, Mr. Das?
My lord,
Age of the petitioners?
age of the 48 months.
Prime of his youth has gone.
Prime, yes, my lord, is without money, my lord. Initially 300, then 3,000, my lord. Obliged, man, deeply obliged.
Item 33.
বিপ্লৱ এটা লাইন লিখি দিবাচোন মোৰ মনত পৰিব the emphasis is on the continuity of service continuous service. Yes.
May I please, Lord? Doctor, this matter pertains to compassion of definitely, Lord. The father of the petitioner died in the year of 2013, Lord. Accordingly, he submitted his application within time, Lord. And his name was represented in a DLC that was held on in the year of 2014, Lord. But his case was neither recommended nor rejected by the DLC, Lord. Now, Lord, I'm basically before this honorable on the basis of the letter dated 14/6/2022, Lord, issued by the Deputy Commissioner, Lord, will find it at page 64.
Compassionate ground.
Lord. Specifically, have a look at page 64. Lord. It's a type copy, Lord. May I read it? Lord?
Who passed away? Your father?
Lord,
When?
2013,
Date?
Lord. 6/7/2013, Lord.
Working where? In what capacity?
Lord, he was a pump operator, Lord. Mr. Pump operator.
Pump operator.
Right.
Where?
Under Demaji division, Lord.
Which department?
Irrigation department.
Thereafter,
Director Lordship, his name was reflected in the DLC Lordship that was held on 18/9/2014. Lord, will find it at page 42.
18/9/2014.
Lord.
DLC meeting.
Lord.
Your name there.
Yes, Lord. But in the remarks column, it was nil, Lord. It's neither rejected nor recommended.
Where page?
Lordship 43, Lord.
4-3.
Lord. My name is serial number 8, Lordship. It's Total of Lahon, Lordship. Son of Atul Lahon.
Yes.
In the remarks column, it was a nil, Lord. So what was the hell with the after examination of the applications, the committee decided to recommend the name of the Arup Gohai again the vacant post of grade 3 considering economic condition, nothing else, Lord. That my case was rejected due to want of vacancies or any other ground.
Where, after exam?
Just the table below the table of from Lord. Last paragraph.
Recommend the name of Arup Gohai.
Saurav Lahon, Lord.
No. After examination of the
Arup Gohai, Lord. Yes. His name is reflected in serial number 3. Arup Gohai.
No, that means the absence of any indication in the remarks column will not have any difference, will not have any meaning because one of the incumbent was recommended because his position economic wise was worse than the others.
Lord, why Lordship I am submitting that the Lordship his name was not recommended or not rejected, Lordship. Lordship kindly have a look at subsequent DLC, Lordship, that is the held on 4/6/2015, Lord. By that DLC, Lordship, that is the held on 4/6/2015, Lordship. Similarly, the DLC recommended similarly placed a candidate, Lord, to the petitioner. Page it starts from 51, Lord.
51.
Lord. Relevant at 50.
Saurav Lahan is the petitioner.
Lord.
Okay, 51.
Yes, Lord. The relevant proportion at 52, Lord.
52, yes. What is
Lord.
the...
Here is the last column, Lordship, serial number 5, Ranjit Borwa. His name was also reflected, Lordship, in the earlier DLC, Lord.
Yes.
But his case was recommended, Lord.
Where is,
Lordship.
Where is Ranjit Burwa in this list? At page 43?
Lordship, at serial number 5, Lord.
5? Where?
Of page 52.
52?
Lordship.
No, that we have got.
Lord.
No, you said that Ranjit Burwa was in the same list. Ranjit Burwa was in different consideration.
Lordship.
How is it
He
relevant?
was similarly seated to the present petitioner, Lordship. Lordship then kindly completely, Lordship, at page 47, Lordship.
47.
Lordship. In page 47, that is the DLC, Lordship, of 2014, Lordship. The name of the Ranjit Borwa is reflected in at serial number 5, Lord. Lordship, got it, Lordship. It is similarly placed out to the present petitioner, Lord.
Page 47 is of which date?
It is, Lordship, of 18/9/2014. DLC, Lordship, hello, for 18/9/2014.
18/9/2014.
Lordship.
Yes, and the in what is this date where Ranjit Burwa has been held to be eligible?
Yes, Lordship, he is similarly situated to the present petitioner, Lord.
Which date?
Lordship, that is not mentioned in the DLC, Lord.
4/6/2015. Why not mentioned? See, come to page
Lordship, that is
51.
the subsequent DLC, Lord. Yes. Ranjit Borwa and Neetu Borgohain. Both were recommended by the...
These are separate consideration. How is it relevant?
Lordship, I am referring this, Lordship, to story that the case of the petitioner was also not rejected by the DLC, Lordship. That is on 18/9/2014, Lord. That is why I am doing this.
No, in this subsequent meeting of the DLC
Lordship.
on 4/6/2015,
Lord.
was your case considered?
Not considered, Lord. Not taken into consideration, Lordship. Now, Lordship, I have a look at the page, Lordship, that is 64, Lordship, the communication made by the Deputy Commissioner, Lordship.
Yes.
Office of the Deputy Commissioner, Demaji, Lordship. All heads of the department The executive is in the irrigation, subject submission of status report of pending proposals on compassionate ground who died.
Page
Page 64, Lord.
64.
Lord.
Yes.
That is subject, Lord. Submission of status report of pending proposals on compassionate ground who died on or before 31/3/2017. Lord. You are decided to complete all the pending cases, Lord. It was issued on 14 June 2022. The deputy commissioner has already filed his affidavit, Lordship, in opposition, Lordship. In the affidavit in opposition, nowhere is stated that the petitioner is not entitled for compassion appointment due to the cause of delay, Lordship, or any other ground, Lord. Affidavit in opposition, Lordship, filed by the Ankur Varale, Lordship, district commissioner, Lord.
But you have come to the court in 2023.
Lordship.
You have approached this court in 2023.
Lordship, they were decided to complete all the pending cases, Lordship.
That was when? Which year?
On or before, who died on or before 31/3/2017.
What was the date?
Lordship. It was issued on 14 June 2022.
See, more than 10 years have passed now.
Lordship,
Can it be considered?
Now the respondents have recommended the cases of even Lordship in 1992, 96, 98. On the basis, since they have decided to complete all the pending cases.
Yes, so see, where
Lordship,
92 cases.
see, affidavit in the reply, Lord.
Yes, page.
Page, Lordship, 88. It starts from 88, Lord.
88.
Lordship.
Yes.
This is the minutes of the district level committee meeting held on 11/2/2022, Lord. Lordship, next page 89, Lord. Assistant teacher, lower primary, Lordship. Details of proposal received. Kindly see, Lordship, serial number 1, Lordship. Madhujya Raidongia, Lord.
Pertaining to elementary education
That is
department.
pertaining to elementary
Elementary
Lordship. But Lordship, they have also placed the cases of the irrigation department also, Lord.
Where?
That is, Lordship, will start from 93, Lordship. It starts from 93, Lordship. The relevant person at page 94, Lordship. It's serial number 1, Lordship. Ratul Shutia. Date of death, Lordship, 10/8/2011.
Page 94.
Page 94, Lord.
Yes.
First tabular column, Lordship.
Yes.
At serial number 1. Ratul Shutia.
Yes.
Date of death, Lordship, 10/8/2011.
Yes.
But the remarks no record found.
Yes.
Next one, Lordship, Sinumoni Gogol, Lordship. 19/12/2013. Placed on 18/9/2014. They again placed it, Lordship, in the year 2022. For third one, Lordship, that is Vipul Lotto. Date of death, Lordship, 27/8/2013. His name was also in the reflected in the DLC held in the up to 18/9/2014, Lordship. Vipul Lotto's name, Lordship. It is also recorded in the remarks column also, Lordship. Mintu Deuri, Lordship. 10/5/2012.
This will not give them any right. This is only the details of the proposal received.
Lordship.
When they are placed before the DLC, that has been recorded. Where is
These
this?
are, these are placed before the DLC, Lordship, is a pending cases, Lord. What
Details of the
exactly-
proposal received. These are the
Lordship.
proposal which were earlier placed, the dates
Lordship.
of earlier placing, and some, for some, no records were found.
The proposals of the present, those candidates were placed, Lordship, to complete the pending cases, Lord.
Where are these incumbents appointed?
No, Lordship.
And if they're not appointed, how does it make a difference?
But Lordship, in our elementary department, Lordship, they have recommended 2006,
Elementary
Lordship.
education is a different, you are in the education department, you are in a different line altogether.
I'm under the same still, Lordship. I'm also.
Hmm? Now, after 10 years, how do you tell us? What is the
They
object?
recommended Lordship in 2006, Lordship in
It can't be a negative
1999.
equality. It can't be a negative equality. It will be very
If I may
simple.
be excused, sir.
Yes,
If I may be.
yes.
In some department, Lordship, the government has decided 1990 cases, Lordship.
That will not mean anything. You have to make out a case after 2013 death. Can we issue a direction to
Lordship,
appoint you?
I am before this honorable only basis of that later dated 14/6/2022, Lord. Issued by the
How do you
Deputy
overcome
Commissioner.
Debabrata Tiwari?
Lordship, this is the policy decision, Lordship.
How do you overcome? What is the objective of the appointment on the compassionate ground?
That is true, Lordship. To
After 10
overcome
years,
the
can-
Lordship. Yes. Immediately is the
10 years,
object
can
behind
you
the
grant,
scheme of the
if they
competition.
give
That is-
you,
that is true, Lordship.
if they give you on their own, we have nothing to say.
Lordship.
We are not against your appointment, but it
Right.
cannot go as a mandamus.
But Lordship, kindly have a look, Lordship, the minutes of the workshop, Lordship, that is filed on 5/7/2021. If a Lordship permits, Lordship.
What is that?
It is, Lordship, chaired by the Honorable Chief Minister, Lordship.
What is about?
In the paragraph 23, it is specifically mentioned that all pending competition ground appointment cases prior to 2007 shall be finalized within 3. All pending cases.
There is no restriction for finalization, but can it go to appoint you?
They can place it, Lord.
So, my lord,
Because similarly, it is the candidates are-
if I go by my affidavit, my lord, in 2014, the proposal for appointment of the petitioner was rejected due to want of vacancy.
Yes.
Means there were once it was considered. Now 2014, he files a writ petition in the year 2023, meaning thereby 9 years he was skipping over his right. And after Debabrata Tiwari, my lord, 2023, immediacy is lost. The very
There is another aspect that the policy to consider as a one-time consideration is for those cases which have never been considered.
never been considered.
Your case was considered once and rejected.
not rejected, Lord.
No,
That
that
is why I am showing the
that-
next DLC, Lord.
that was before 2017. If your case, if you thought that your case should have been considered once more, you should have come to the court.
Lordship, since they state has decided to complete all the pending cases, Lordship, I am
Pending
on
cases,
that
what
basis, Lord.
those cases were not considered at all. Your case was considered. It did not come into the within the zone of competition. There was one candidate found to be whose economic condition was worse than you. Not only you, the other candidates.
Lordship, the Deputy Commissioner instructed the executive engineer by the state later, Lordship, 14/6/2022. to
All said and done, how do you overcome the essence of the objective of the scheme? How do you overcome that after 10 years? Can you issue a mandamus which is in conflict with Debabrata Tiwari?
they have recommended their own Lordship.
If they do it on their own,
case of
I would have told you, if they do it on their own,
1999 cases, Lordship, 2006 cases, Lordship. By
Yes.
person to this for have minutes of the workshop, Lord.
Where are the appointments? Show us the appointment.
Yes, Lordship, appointments, Lordship,
Where?
SLC, Lordship.
No, show us the appointment order. Show us the appointment. Give us the details of the appointment order. You may not have the appointment order. So you give us the details at least. Who is appointed, whose father or mother
Lordship,
was.
then Lordship, to kindly have it another date. Lordship.
After 10 years, we cannot. If it is granted to somebody, we cannot give it.
SLC selected Lordship by August 26th, Lordship, 26th of August, Lordship.
So we have to be consistent. We cannot, our orders cannot be in conflict with what has been laid down by the Supreme Court.
My lord,
Lord,
after
yeah.
2023, my lord, there cannot be, my lord. So there was Tibari, my lord.
Lordship. I have annexed to one another as the TLC Lordship, that will find at page 99 of my affidavit in reply, Lordship. What my learned is submitted, Lordship, to reply, that's one, Lordship. At page 99, Lordship.
Cannot be a fit case.
Lordship, kindly, Lordship. Kindly have a look.
No, after 10 years, just make us understand that after 10 years, you can be appointed on compassionate ground. Whether others are appointed or not, we are not too much concerned. Make your own case that after 10 years, you can be appointed on compassionate ground, that you meet the requirements of the scheme of compassionate appointment.
Policy decision taken by the government.
What is that? What is the scheme of compassionate appointment?
It's mentioned in the minute, Lord.
What is the scheme? Why is the scheme there? Is it a mode of appointment?
No, Lord.
It is an exception to the normal mode. 5% has been carved out. It's only for to give immediate succor. After 10 years, where is the urgency? Immediate need. How do you overcome that?
Decision of the government.
You come after 9 years and you are banking on the decision of the government. You bank upon the decision.
Taken it on 2021.
Then you wait till another 10 years.
But they have taken it on 2021, Lord. But you kindly have it another day, Lordship.
Sorry. After 10 years,
There cannot be any contempt.
it cannot be.
Lordship, kindly have a look, Lordship, my affidavit reply, Lordship. Kindly, Lordship.
We have, first you explain to the court that after 10 years and direction to appoint you will be in consonance with the scheme. Fulfill that requirement, we are going to pass an order in your favor. After 10 years, you fulfill the requirement of being within the fitness of the scheme. That's all. Where is the urgent necessity? Where is the immediate need after 10 years? It's not a right.
True, Lord.
It's not a right. It's an exception to the recruitment rules.
Lordship. They have the recommended 2004, 2001, Lordship.
3. Here, BK Gogoi,
Lord.
learned counsel for the petitioner, also heard 3. Heard her, learned state counsel. Madam, you are appearing. And Miss D.S. New, learned standing counsel for the irrigation department. Put the para. The claim pertains to an appointment on compassionate ground. Para. The facts projected is that the father of the petitioner, Atul Lahon, was working as a pump operator in the irrigation department, and he had died in harness on 6/7/2013. Full stop. The petitioner had made an application for appointment on compassionate ground, which was forwarded on 6/1/2014. Full stop. It is the case of the petitioner that though the district level committee meeting held on 18/9/2014, the name of the petitioner was reflected, there was neither any rejection nor recommendation. Full stop. It is submitted that persons whose names were considered in the meeting held on 18/9/2014 was again considered in subsequent DLC and was approved and was recommended. Full stop. Para, Sri Gogoi, the learned counsel, has submitted that a policy decision was taken for one-time consideration of all cases pertaining to compassionate appointment whose the appointment where the death was prior to 2017, 31/3/2017.
Right, all
And
of it.
the Deputy Commissioner Dhemaji had issued a communication on 14/6/2022 to submit all pending cases, full stop. However, the case of the petitioner has not been considered, full stop. Para. Sri Gogoi, the learned counsel, has submitted that once a policy decision has been taken for consideration of all cases where the death was prior to 31/3/2017, comma, non-consideration of the case of the petitioner would be discriminatory. Full stop. He has also submitted that similarly situated cases have been considered and recommended. Full stop. The learned counsel has, however, not been able to produce any such final orders of appointments, nor any details of any appointment made have been pleaded in the writ petition. Full stop. Par contra, comma, Sri Dhar, the learned counsel, learned state council, has raised the issue of delay and latches in approaching this court. Full stop. It is submitted that the death was in the year 2013 and the writ petition was filed only on 5/8/2023. That is after about 10 years. Full stop. It is submitted that the essence of that the objective of the scheme for appointment on compassionate ground is only to give immediate relief to a bereaved family which has lost the sole breadwinner of lost the sole breadwinner. Full stop. The state council has also referred to the case of Debabrata Tiwari versus State of West Bengal versus so and so, report and so and so, and has submitted that after 10 years, comma, no direction can be issued for appointment on compassionate ground. Para. Ms. Neu, the learned standing council, has endorsed the submission of the learned state council. Full stop. Para. The rival submissions have been considered. Para. The present writ petition and the present challenge is primarily based on a policy decision to consider all cases for compassionate appointment where the death is prior to 31/3/2017 as a one-time measure. Full stop. Prior FSI, comma, it appears that in the DLC meeting held on 18/9/2014, the case of the petitioner was indeed considered, and amongst 10 numbers of aspirants, comma, one aspirant was recommended by the DLC as considering his economic condition. Full stop. The same indicates that there was a one-time consideration. Full stop. The policy is only for those cases which were yet to be considered, and therefore effectively, comma, the petitioner's case would not be covered under the said policy. Full stop. In any case, comma, the objective of offering an appointment on compassionate ground is only to give immediate succor to the bereaved family which has lost the sole breadwinner, and there would be and after a decade from the said death, no such directions can be issued than by the Devabrata Tiwari statement. In view of the aforesaid, no relief, this court is of the considered opinion that no relief can be granted to the petitioner, and accordingly the writ petition is dismissed. আগর তিনটা করে দিব compassionate appointment or asan তিনটা
Published.
May I please, Your Lordship? My lord, before going to the other aspect of the matter, my lord, I filed a representation, my lord, that is at page 58, my lord, annexure 11.
5-8.
5-8, my lord, annexure 11, my lord. This is, my lord, revision of appeal, my lord. I filed the appeal, then the appeal was, my lord, not considered. Accordingly, my lord, as per the observation of the appeal, my lord, I filed this revision of appeal on 22/9/2021, my lord. And the authority has not entered in the same yet. Even, my lord, as per direction of this honorable court, my lord, in this proceeding, my lord, I filed a representation again before the authority on, my lord, 15/9/2023. I have the receipt copy, my lord. My lord, yet they have not considered the same. My lord, kindly, that may be disposed of, my lord.
With what?
This, my lord, representation, my lord, I filed in 2021, my lord, 22/9/2021, my lord, annexure 11.
You filed writ petition for a direction for disposal of representation?
Yes, my lord.
Sorry. Will not
No,
direct.
My lord,
You have come to us, we'll decide on merits. Why should it? It's not a post office.
No, my lord, my case is partly different.
You replace your case. It's not decided by them. We'll decide.
Then, my lord, my humble prayer is that.
What is the cause of action?
Yeah, cause of action is, my lord, that it is, my lord, page 37, my lord. Page 37, my lord, and it's a 4. This is an order, my lord, of 1994, my lord, whereby, my lord, the petitioner was discharged from service.
In the criminal case, you were acquitted.
Yes, my lord. In the criminal case, I am acquitted, my lord.
Yes, thereafter.
My lord, thereafter, I filed the appeal before the authority. It is on, my lord, annexure 6, my lord. Is my lord 47. It was filed on 25/2010, my lord. Thereafter, my lord, annexure 7, my lord, page 50. It is the order of the
Yes.
appeal.
What is this? See, the rules governing the field stipulates provides for an appeal. Initially, the appeal was rejected.
Yes.
And there was an observation that after the acquittal, he could file a revision of the appeal, which he has done. Why don't you consider?
That part only. Yes.
You get instructions. Is there any order that no bar for? Is there any order?
No, my lord, regarding.
You have not, have you filed? Who has filed? Who is respondent of 5? Mr. Das. 5 is who? Commandant.
Yes, my lord.
Filed affidavit.
Yes, my lord. We have filed
What has he said?
Commandant, this affidavit, my lord. In the affidavit, my lord, they have in our paragraph 6 and 7, my lord, we have stated regarding this revision of appeal, my lord. And so far this page, paragraph 6 and 7, my lord.
Yes.
They have referred that they have no comment, my lord. It is at page 64, my lord. Running piece.
Yes, we are in page 64 only.
Paragraph 8, my lord.
Yes.
That with regard to the statements made in paragraph 6 and 7 of the writ petition, I have no comment to offer.
I think they haven't considered it as of now.
Mr. Das, where is that communication whereby you were directed to file revision of the appeal?
Yes, my lord.
His representation, my lord, is that is annex 11, page 58. That is before the DGP.
It is,
So, but maybe the commander doesn't want to make any comment in his affidavit. So, my lord, can dispose of the matter, directing the authorities to consider it, my lord.
No, it should be brought to a logical conclusion. He cannot be made to hang
Yes, my
like
lord.
this.
and it is, my lord, Annexa 9, my lord.
And he may be right in contending that at this stage, we may not go into a big, because appeal, it's a statutory provision.
Yes.
The rules provides for appeal.
Rules provide
You
for
may
my lord.
reject the appeal, you may
Yes, my
allow
lord.
the appeal.
Yes.
And
Thereafter-
he is also equipped with the instructions that in the criminal case he was acquitted. Whether that will be a ground for you, that's for you to decide.
Yes, my lord. Exactly. So, my lord, let the authority take a call, man.
Hmm?
That is why, my lord, the commandant remains silent.
And my lord, it is Annexa 9, my lord. What lordship is asking, my lord.
Page.
Page, my lord.
Who is the
50,
appellate
50, my lord.
authority, Mr. Das? DGP.
My
Respondent number 2. Who is the appellate authority?
Appellate authority is DGP, my lord. DGP, my lord.
Respondent 2.
Yes.
Respondent
Where
number
is that letter?
My lord, page 58.
Page 58, my lord. Annexa 11.
58. No, this is your letter. No, where is that letter by which you're advised to file?
Yes, my it is page 53, my lord. Annexa 9.
53.
Yes, my lord.
Mr. Dhar, this is not a case of directing for considerable representation. It's a statutory appeal. You're bound to consider. PK Das.
Yes, sir.
Heard Sri PK Das, learned counsel for the petitioner. Also heard Sri Ardhar, learned state counsel. Full stop. Considering the facts and circumstances, and as agreed to by the learned counsel for the parties, comma, the instant petition is taken up for disposal at the admission stage. Full stop. Para. The facts projected is that while the petitioner was discharging his service as, you were what?
Constable, my lord.
Constable.
Yes.
Where?
Page 37.
Where? Which place?
It was at Fazua Bill, my lord, training center.
Page?
Page 37, my lord. Annexa 4.
While while he was working as what? Now, as constable in the under the 3rd AP Task Force Battalion, Khajua Bill. Which district, Khajua Bill?
Fazua Bill is at Darang, my lord.
The district of Darang, comma, he was discharged from service by an order dated 31/1/1994. Full stop. The said discharge was without holding any departmental proceeding. Full stop. On the very next date, comma, on the allegation that some ammunitions were recovered from his possession, comma, the petitioner was arrested in connection with Dolgaon PS case number
15 of
1994. Registered under section 25 within bracket 1 within bracket A /27 of the Arms Act. In the aforesaid case, however, the petitioner was acquitted, vide an order dated 22/4/2010 passed by the learned session judge, comma, a session judge in sessions case number 74 within bracket DM of 2008. Session judge, this is Durham.
Yes.
Session judge Durham. The petitioner had thereafter preferred a departmental appeal on 25/2010 for his reinstatement in service. Full stop. The appeal was, however, rejected by the appellate authority on 16/11/2010. Full stop. The petitioner had thereafter submitted another representation of oblique appeal on the ground that is there any provision to file revision of appeal
Yes, my lord, provision is there.
under
Revision of appeal is there, my lord.
Mr. Dhar? What is this revision of appeal? One appeal rejected, another appeal rejected. Same. Hmm?
Appeal petition. But my lord, appellate authority is, my lord, the DGP. That's before the DGP, my lord, not commandant.
Oh, no, let's. But this will be unending, Mr. Das.
My lord.
Appeal was rejected, again your representation thereafter rejected, again third, rejected with an observation that you can go to the appellate authority to revise his order.
It is, my lord, as per their direction, my lord, I am reposting, my lord. It's a layman, my lord, kindly.
Now, under what provision is there? How can we pass an order for? At best, there could have been review, but where is the question of revision of appeal?
Appellate authority come.
See the appeal, Mr. Dhar.
Yes, 2017.
Appeal was rejected in 2010.
Yes.
Then he files another appeal.
Yes.
Which was also rejected in 2017.
17. By the appellate authority then by.
Yes.
He is the appellate authority, my lord.
Yes.
17.
Then he files another representation 2021. Where is the provision of law?
My lord, appeal, it was revision of appeal provision is there, my lord.
Sure.
That provision is there, my lord. My lord, rule this 27 may also be applicable.
Please
because
read.
It's review of orders in disciplinary
This
cases.
review is different.
Review
is different. That is why we use this expression review. This is not a review. And even review, there will be a time limit. The initial appeal was dismissed in 2010.
17.
No, in the initial was 10,
Initial was 10.
2010. 16/11/2010.
But this, my lord, annexation 9, it is of, my lord,
Discharge is of the year 1994. I think it's a absolutely stale claim.
and my lord,
Shows the provision of law.
revision of appealment.
An appeal. And judgment delivered on 2010.
We'll consider some other day. I don't think we can pass this
My
order.
lord, in the meantime, we will file the reply also, I thought, against
Not
their
proper.
affidavit in opposition, my lord.
The 94 discharge ultimately are coming now in 2023. Appeal dismissed in 2010.
After the judgment. Then.
No judgment. Judgment was long time back. That is also not correct.
It was in 2010, my lord.
2010. 22/4/2010.
2010, yes. 22/4/2010. And that appeal was rejected thereafter.
Yes.
He filed the appeal after the judgment. That was taken into consideration, acquittal.
consideration.
Still rejected, nothing
Yes.
done from 2010 to 2013, 2023. 13 years. Ridiculous. An affidavit in opposition has been filed by the respondent number 5 on 22/7/2024. Full stop. 3 Das, the learned counsel for the petitioner, prays for and is granted 3 weeks time to file rejoinder affidavit. Agorkan eligible. PK Das, huh? PK Das.
Item 55.
This case relates to the sexual harassment to women at her workplace. Earlier, as she lodged the complaint on 2nd of February 2023 itself.
Yes, your response?
My lord, we have filed, and my lord, we are considering to his prayer. My lord, there was since the officers was not the prayers, officers are not properly instructed in law, my lord. His basic contention is that committee, internal committee, which should be headed by a lady. We didn't have that officer, my lord. My lord, we'll reconstitute and bring one officer from other department and reconstitute, conduct an inquiry.
That is the main grievance.
Yes, my lord. My lord, kindly go to the.
They should have a internal committee, every employer, but there is no internal committee. Only after lodging.
Which organization?
Assam textbook.
Yes.
You have an internal committee?
We have a committee, my lord.
Now, after
It's long
lodging.
time Visakha has been pronounced.
Yes.
Yeah, till now you don't have a committee.
we have
This is not good.
Yes, and there is panel
Your
provision.
pronouncement is transformed into a statute now.
Yes.
Statute you are not giving.
That concession will be done, my lord. But he was given a hearing. And
No, he has to do it by in accordance with law.
We'll do it, madam.
And there is, for non-compliance of the provision, there is penal provision also. And she has been suffering, she has been thrown out, she was in contract. She was in
So
contract.
when can you come up with country instructions regarding the committee?
We can come with next week, my lord.
Next week.
But my lord, Mr.
Come up with the committee.
Yes, sir. But my lord, he is mixing two prayers, my lord. The contract period of the petition is already over. That is gone. And the
only due to this complaint,
my lord. That's
not
a different
ready.
issue, my lord. He's trying to.
No,
present a
you
different-
first
We'll form a committee, my lord. We'll come.
You fulfill the statutory
My lord.
requirement. Okay. First, 3 NK Kolita learned counsel for the petitioner. Para 3 D Gogoi learned standing counsel.
Assam textbook.
Assam textbook publication
And publication and production corporate.
and production.
Production and publication corporation limited.
Production and yeah.
Production and publication.
Praise for and is granted 10 days time
10 days, man.
to 10 days to obtain instructions regarding formation, constitution of the internal
ICC.
internal complaint committee.
ICC, my lord, internal complaints committee.
Complaint committee, within the ICC, which is a requirement under the, give the name of the act.
Sexual harassment of women at workplace, my lord. Well, I'll give the name.
Give the sexual harassment of women at workplace. List on, we give a date. List on.
My lord, 6th.
Not on 6th, on 12th. 12th August.
My lord, on 13 can, 13 on 14, my lord.
13th, we can have it on 14th.
My lord.
14. All right.
14th.
Here's for respond number.
What is your name? J? Bormon. R5. Yeah.
All right.
Okay.
May I please, Your Honor? But this better relates to appointment of constable tradesmen in BSF, my lord.
Yes, madam, your response.
We have sent the affidavit for taking. So.
Let them file. Okay.
I'm appearing for 1, 2, and 3.
State is also a party. Whose affidavit will be required? Central government. On the prayer of Miss R. Devi, learned CGC, matter is adjourned by 3 weeks to enable filing of affidavit in opposition. Okay.
Date may be fixed if possible.
Let them file. We consider.
Matter pertains to the disciplinary proceedings to the petitioner, my lord.
There's an interim order protecting.
Interim order of protection.
Lordship, on it
You
was.
filed your response.
We have filed our affidavit in office on the date of returnable date, my lord, and they have failed to file the affidavit in reply since
It's
last 2
not
days.
My lord, it
This
is
will
not
be the
exactly
third
we
date,
have
madam.
failed. It was listed on 19. That day, because of their request, it was fixed on 31st. However, your
No,
lordship was
because we
giving
have
us
failed to
a
file
bit
the
more
affidavit
time.
in reply, my lord.
In fact, I was
My
asked
request.
whether I would be able to give my reply by 30 because the petitioner's wife is in hospital. This is the medical. Yesterday, she has
Okay,
been
when can you file the reply? Tell us.
Sir, yesterday she has been hospitalized. So
You
it
tell
will-
us when can you file?
Sir.
I remember, it was fixed at your instance. You were not there.
Huh.
I
We
was
had
not there,
requested-
but she has
No, she prayed for 2 weeks' time, but on your request made on your behalf, we had
Yeah,
fixed it.
because she had called me up over phone that she'll be taking time for filing the affidavit.
Yes, I
in
have
reply.
already informed her.
No, that
Sorry,
we
informed.
remember. We said that if you are not being able to file, we'll grant some more time. When can you file? Tell us.
Sir, after 15th of August.
Why 15th?
Because she is
On last
hospitalized.
occasion, they have taken time
No,
that
she
he
is
is
having
residing
operation.
at
That
residing
is
at Impol, my
unsuccessful.
lord.
They are residing
What
in
is the
Manipur.
matter?
Matter is, my lord, the disciplinary proceeding focus notice was issued. The petitioner has filed challenge this focus notice on the ground that the matter is pending before the CBI court, and her ground, if she file the written statement, he will be prejudiced. Simple on that ground.
No.
What is your call? What is your take?
Now, my take is that he has been charged for misconduct, and the CBI case is on some other ground, my lord. Though the list of witnesses are same, he was caught red-handed by the CBI on the complaint made by the contractor for taking bribe. That was caught red-handed. CBI has filed charge sheeted, and we have also charge sheeted him on the ground of misconduct, tarnishing the image of the FCI. Now, on that ground,
But relating to the same incident.
Yes.
relating to the same incident, madam.
Witnesses
There
are
is a
also
coordinate bench order that has not given the interim order on the similar case. Plus, my lord,
Won't she suffer prejudice if she is made to disclose her defense in the disciplinary proceeding?
my lord, there is a Supreme Court judgment also that it can go together, my lord, because
Which one?
that is the
Which one?
Sir, I have also Supreme Court judgment.
once Captain
Captain Anthony is of age which is long over. Which is the latest judgment?
Latter reason is this Rajasthan High Court, my lord. On the
What
similar
Rajasthan High Court?
circumstances of the FCI matter, my lord.
So this is the latest one.
We will convince your lordship.
You are also on the age
Short
of
date will be given, my lord, we will convince your
Captain
lordship.
Paul Anthony is long over.
But still
are
holding
going
the
back
field,
30
my lord,
years.
still holding the field.
You are not abreast with the law, both of you.
I have
Unfortunately.
other judgments also, my
Of
lord. where
Rajasthan High Court.
Supreme Court has categorically stated that it should not be kept long pending because the criminal cases will go.
Yes, what is the time limit? Which case?
My lord.
You don't know, you're not equipped with the case. Why should we advise which case? We will not do research for you.
My lord, what latest decision?
Which case has laid down a guideline that 1 year should be the time?
What my lord, Eastern Coalfield Limited, decided on my lord, 7/4/2022, my lord.
What has been said?
It has been stated, my lord, that it should not be kept for long pending, my lord.
Long pending. So what is it? When was the
So this proceedings should go on, my lord. Disciplinary proceedings should go on.
simultaneously?
Because this criminal case.
So when did you
criminal
start the
case
disciplinary proceeding?
we have issued stoppers notice on last year in the month of December.
December. There is a timeline given by the Honorable Supreme Court in one of the cases.
4/11/2022.
You are correct that indefinite it cannot go on.
Yes, ma'am.
But at least should give some time that in the criminal case.
That has also been challenged by the petitioner in the criminal revision petition. That is also pending.
Which
It will
one?
definitely go along.
Which one?
That
For
that's
quashing?
solicited for quashing.
Is there any interim order?
No interim order.
Then
That
trial
one
is-
is submitting, my lord, it
trial
will
is
go on,
going-
my lord.
It is not yet listed, your lord.
you file your affidavit and reply.
Yeah, we'll try to file only my predicament is the
Only
medical.
ground is that the
Miss-
petitioner is
Miss
saying it
Kumari-
is all, my lord.
Then it counsel for the
And there
petitioner.
is staying in the Manipur.
Prays for. And is
Can be
granted,
notarized and can be
granted
submitted.
2 weeks for the time to file the rejoinder affidavit. List on, we will fix a date. List on 14th of August. You file it before that. You ask for 2 weeks, you are giving 14 weeks. 14th,
16th of August, fine.
16th, Friday. Okay, 16th,
But on 14th, I may not. be-
16th.
16th
16th.
You file it.
of like
And
Sri
we
BK
may time
BK Singh.
be extended here.
Then it, counsel for the FCI.
FCI.
FCI is present. He
Interim
is
order may kindly. be-
interim order passed early to continue till the next date of listing.
Much up.
BKC.
Item 38.
Yes.
Yeah.
Response. Full files, PNRD or government.
Extra copy yet to serve, lord. So that's why not.
Why don't you give extra copies?
Okay.
Return number. Pre Sakya, the learned counsel for the petitioner, undertakes to serve extra copies of the writ petition to the learned counsel for the respondents by tomorrow. List after 3 weeks to enable the learned counsel for the respondents to obtain instructions.
Item 39.
May it please your lordship. Lordship, in this petition, lordship, my lord, the petitioner, my lord, while he was serving as a junior engineer, PHC department, my lord, a case was registered against him under section 7A of the PC Act. And thereafter, my lord, the petitioner was arrested on 15/12/2023. And thereafter, my lord, on 17/1/2024, I was granted bail by the special judge, and thereafter I went to join my office. But my lord, I was not allowed to join by stating that a suspension order has already been issued. And thereafter, my lord, on 24/1/2024, my lord, I got the suspension order, my lord. Lordship will find at page number 26.
Yes, what is your instruction?
Lordship, I just placed a copy of the instruction, Lord.
What is it?
Thereafter, my lord, no periodical review, my lord.
Yeah, we should the memo of charges.
Yes, sir, Lord.
Inquiry has started.
Inquiry started. Now the matter is now.
Inquiry report has also been submitted.
Yes, the inquiry report submitted by I on 10/12/2024. The matter is now in the process of finalizing the penalty of the delinquent.
My lord, I have no, I faced in, my lord, one application, my lord.
Yeah, Mr. Doctor.
Yes, my lord.
Mr. Doctor, the inquiry is at the verge of completion.
But my lord, may kindly see, my lord, one application, my lord, I have submitted, my lord.
Page.
Page, my lord, 35, my lord.
3-5, yes. What is it?
Page 35, my lord, so cause, with regard to so cause notice dated so and so. My lord, may kindly turn page 36, para 2, my lord. That the so cause notice was issued against me for alleged involvement in ACBPS case number so and so under section so and so. From the so cause notice dated so and so statement of allegation, it is understood that the allegation is of demanding and accepting bribe and my subsequent arrest. The allegations labeled are similar and identical with the charges.
These are your response on the merits of the charges. They'll consider inquiry is already over.
No, my lord, I have, my lord, made an application, my lord. This they have humbly prayed before a good self would be pleased to drop the instant disciplinary proceeding against me and allow me to resume my duty for bread and butter. And under
The inquiry is already over.
my lord, if you, my lord, third last paragraph, my lord, under the aforesaid facts circumstances, in case if you still want to proceed with the instant disciplinary proceeding against me, in that event, I hereby reserve my rights to file the detailed written statement in defense after being informed from your good office in writing about your intent to proceed further with the instant proceeding. My lord, that application I was submitted, my lord.
Mr. Datta, the inquiry is over. You are on the stage of filing defense statement. Show cause given, defense statement given, inquiry is over. Have you taken instructions from your client?
My client has not received anything, my lord. After sending this letter, my lord, nothing of that sort, my lord.
How could the inquiry be over then?
Yes, even
That is,
we have given
my lord, I am
every
very surprised,
timeline
my lord.
instruction, every timeline of
Inquiry report has been submitted on 12/7/2024.
My lord, I am very surprised because, my lord, after this letter, my lord, letter dated, my lord, 6/4/2024.
They have given a timeline and entire thing. The departmental procedure, the disciplinary authority had appointed the IO inquiry officer and presenting officer on 13/6. The enhanced subsistence allowance was issued on 27/6. Inquiry report was submitted on 12/7.
the matter is under process finalizing penalty.
When did you file it? When did you file this writ petition?
My lord, I have filed this represent on 25/6/2024.
From 13/6 to 12/7, the inquiry was held sometime between that in that period, because the appointment was on 13/6. Report submitted on 12/7. Those submissions will be redundant. That I need to give a defense statement, keep the disciplinary proceeding in abeyance. Inquiry is over.
But my lord, I have submitted this application, my lord. Way back in, my lord, 6/4, my lord.
6/4.
6/4/2024, my lord.
6/4. Thereafter, appointment was made in June.
But my lord, at least I would have given that opportunity to defend my case, my lord.
How do you know that you have been given or not?
My lord, no such communication, my lord. Nothing of that.
You
sort.
applied the inquiry proceeding.
And after filing of this, my lord, this writ petition, my lord, this court, my lord, on the first day, my lord, directed, my lord, to give me the subsistence allowance at an incremental rate, my lord.
This is given on 27/6.
Yes, thereafter, my lord, after 2 days, my lord,
Yes.
that was given, my lord. And I am getting, my lord, subsistence allowance in an incremental rate, my lord. And my lord, the issue, my lord, this is, my lord, exactly, my lord, similar, my lord. And because in this writ petition, my lord, I have also prayed for, my lord, my lord, staying of this, my lord, disciplinary proceeding.
Mr. Doctor, why don't you understand? The prejudice will be at what stage? The prejudice will be at the stage of the inquiry when you are required to disclose your defense.
Yes.
That stage is over. Now, where is the requirement of stay? Where is the scope to stay? Now they are at the stage of imposing penalty upon you. That is the instruction, written instructions. You finalize and give place the instructions.
Very well, officer.
Part 3. M. Datta.
Yes, brother.
Learned counsel for the petitioner. Puts the para. 3 R. Gogoi, learned standing counsel. PHE department has submitted that as per written instruction, the inquiry has been conducted and the inquiry officer has submitted the report on 12/7/2024, and the matter is under process for onward steps. Full stop. Sri Datta, however, submits, Sri Datta does not counsel for the petition, however, submits that he does not have instructions in this regard. Full stop. Para. Let this matter be listed after 3 weeks
3 weeks. Okay.
to enable the learned counsel for the parties to obtain the latest instructions. Full stop. Sri Gogoi may also place before this court the status of the proceeding on the next day.
Very well. Obliged.
Okay, next.
I think 41.
We are going to withdraw my. Nothing survives in this case. The compliance has been done.
Okay. A year for whom?
For the Punjab National.
Officers were made parties.
Yes.
And Mr. Sayola?
16.
Okay. Heard Sri S.K. Singh, learned counsel for the learned senior counsel for the petitioner. Also heard Sri S. Datta, learned senior counsel for the respondent. Full stop. Para. Sri Singh, the learned senior counsel for the petitioner, has submitted that by flux of time, comma, there is no requirement for pressing the instant petition connected, which was filed alleging non-compliance of the judgment and order dated 25/2/2021, passed in WPC 8227 of 2019. Full stop. Para. In view of the above submission, comma, this court is of the opinion that the present proceeding is not required to be continued any further, and the same is accordingly closed.
Obliged.
Obliged.
42.
Well, as regards the release of the amount, but I have received the latest instruction. Well, the department has said that already proposal is with them and it is under process. So it
We
may,
grant some time.
it may,
Okay.
it may
Sri,
take-
I heard Sri. Mr. Chaudhary, your name is not there. Your name is not there. Okay, another. Heard Sri D. Chaudhary, learned counsel for the petitioner. Para. Sri D. Nath, learned counsel for the respondents. How many of them? All
2 months.
respondents. However, submits that the process is on for compliance of the order in question. Full stop. He has also placed on record a communication addressed to him whereby it has been stated that the proposal for financial sanction for arrear salaries in respect of the petitioner has been submitted to the IG prisons. On
IT presence is submitted to government.
IG prisons on 17/7/2024.
IT presence are submitted to the government.
He has also submitted that the IG prisons have submitted the proposal to the concerned department. What's the para? In view of the above, comma, the matter is adjourned by 3 weeks to enable Sri Nath, the learned counsel, to obtain the up-to-date instructions. Do you have a copy of this?
Well, I'll
We'll make a copy.
I'll give it.
Much.
Mr. Chakraborty, for which matter? 4:15? 4:15, you should be at home.
Okay.
40?
But the service is complete upon the all the respondents from 8 to 12, my lord. As per the office note 17/7. But none has been turned up by PAPR representing government. PCLT to ভাগ করে দিন।
8 to 12 complete. Who's for 1 to 7?
I am appearing 1 and 2 lordship.
3 to 7?
1 and 2.
Who's for 3 to 7?
3 to 7 lordship, Dima Hasao, SC Dima Hasao lordship.
Okay, where are they?
3 lordship, 4 and finance lordship.
6 to 7, it's
1 to 7 are official respondents, Mr.
Yes, sir.
Monta?
Yes, my lord. All
Yeah.
are official.
8 to 7.
These are all private.
8 to 12 are private respondents. Okay. Have you filed your response?
No, Lord.
Oh,
perfect.
Hearts 3P Mahanta, learned counsel for the petitioner, who has referred to the order dated 17/7/2024, passed by the learned Lozima Court, full stop. Peruse the said order, full stop. Service upon the respond numbers 8 to 12 is accepted to be complete. The learned counsel appearing for the official respondents pray for and are granted 3 weeks time to file affidavit in opposition. The respond number 8 to 12 may also, in the meantime, enter appearance and file affidavit in opposition. If so advised.
Kindly reflect the name of SC Dima Hasao lordship.
SC Dima Hasao, SC NHAC.
NHA.
NCHAC, huh? May be reflected in the cause list.
Possibly.
46.
This is one of the similar review petitions where the taking the repetition matter was not brought to notice.
Oh, yes.
Matter. I have a copy lordship permit of a similar review petition.
Paragraph number you have?
Paragraph number I have indicated, my lord. Here the paragraph number will be of the read petition. The paragraph number will be 12.
Have you indicated here?
Yes, my lord, at page 5.
Okay.
Two differences will be there, my lord. One is it will be paragraph number 12 of the read petition. And here all the persons they have obtained TET in 2019 and except petitioner number 10, others have obtained DLED also in 2009.
It is,
and 10 does not have DLED.
to make it clear that the TET qualification obtained percent in exam held in the year 2019.
19.
And petition number 1 to 9 obtained DL add in
2019. Except petition number 10, who does not have DLED, he has BLED.
The TET aspect will not be here.
Madam?
Will the TET aspect be here?
Yes, madam. They have 1 to 10, everybody TET in 19. No difficult. And all DLED in 2019, except
Okay.
number 10, who got a BL. That is the only.
Yes, star
Otherwise,
वाला ये स्टार के बाद ये आएगा ये स्टार के बाद मैं देख दूंगा. Okay, you take steps by registered. Where is the second? Where is the last page? Okay, registered post to DD. How many respondents are there?
10.
10 respondents.
10.
Within 2 days, huh?
2
Steps
days.
within 2 days. Okay. Same order, huh?
In this case, this stick was taken on the respondent number 4 and 5 on 12/6/2024.
12/6.
Yes, ma'am.
Office note is there. Office note there or not? Hmm. Office note dated 25/6/2024 reflects that steps for service upon respondent numbers 4 and 5 have been taken by registered post with AD as well as by usual process. Full stop. List after 2 weeks along with press service report.
Lord, here I'm representing the ONGC and I seek time, 4 weeks time to file.
You are representing whom?
ONGC, my lord. And
Okay.
the respondent number 2 to 10, there are different officials of ONGC, except respondent number 11, who is made a party by name. I do not know why he gets it.
You're for 10.
I have filed my wakalat number since I received it, but I have instructions. Since I am the counsel for ONGC, I'll represent the respondent number 2 to 10.
2 to 10. Okay. What about 11?
11 is a person by name. I cannot represent him. I do not know
Did you
why he
take
has
steps
been.
for the 11
Yes, sir. My
by
lord,
substituted method?
we have taken a step for service of notice by publication in local 2 local newspapers.
You had published.
Yes,
Did you file affidavit?
yes.
Yes. Where are the papers?
It is in notice.
As the counsel, you should give the original paper, file the original paper, not like this. Photocopy is not permissible. You have the papers or not?
Original paper I have annexed with the affidavit, my lord.
Where? You have photocopies. Should give the originals. You file an additional, we'll deem it to be complete. Okay. What is your name?
JP Borua.
Sri JP Borua, learned counsel for the petitioner. One petitioner. Petitioner submits that pursuant to the earlier directions passed by this court, paper publications have been made for service of notice upon the respondent numbers 2, 5, 9, 10, and 11. He has also referred to the affidavit filed on 2nd July 2024 in this regard. Full stop. The affidavit has been produced. Full stop. The photocopies of the newspapers have been containing the relevant notice have been annexed. Full stop. The original newspapers are required to be filed, which the learned counsel would do within a period of 2 weeks from today, within a period of a week from today. Para Sri S. Chakraborty learned counsel, who had appeared for the respondent number 10, has clarified that he would be appearing for respondent numbers 2 to 10. Full stop. Sri Chakraborty, the learned counsel, prays for and is granted 3 weeks time to file affidavit in opposition, 4 weeks time to file affidavit in opposition. The service otherwise is held to be complete as the other respondents are represented by the learned CGC.
Pray for a date, my lord.
File it. Is there an interim order?
No, my lord.
File it 4 weeks. (49), what is this?
Lord, I'm appearing on behalf of respondent number 11. We'll file our affidavit as well as the wakalatnama. Kindly 2 weeks time may be given.
You have filed the affidavit.
Yes, sir.
2
We
weeks
have to-
for, why do you need 2 weeks?
We have to file our wakalatnama as well. We have.
We need time to file
Need
an
time.
affidavit.
Oh, you need, you have not filed as yet.
Lot, we file.
What is your name?
Miss P. Bora.
And Mr. Sekya?
Yes.
Filed, affidavit filed?
Yes.
Okay. You would like to file some rejoinder
Let me, I have filed my affidavit in reply, my lord. I have
to
filed my,
Mr. Sekya's affidavit.
I have filed.
While affidavits have been exchanged between the petitioner and the respondent numbers 1 to 10, comma, Ms. P. Bora,
Yes, sir.
Learned Counsel, has submitted that she has been instructed, she and her colleagues have been instructed to appear on behalf of respondent number 11. Full stop. She accordingly prays for and is granted 3 weeks time to file the necessary wakalatnama and the affidavit in opposition.
Highly obliged, Lord.
I filed by me,
I for
applicant for modification and the cancellation of the interim.
I for modification
Modification.
of which order? Stay
My,
order. Modification of what?
order dated, order at page 17. So far as suspension is concerned. And the direction of this honorable court that till the next retaliable date, impugn order dated 21/11.
You are placed under suspension.
Yes, my lord, suspension already stayed, my lord.
Already stayed.
Now they have come for vacation. In the main petition, my lord, they have filed affidavit and we also file counter affidavit and all pleadings are completed. Main case may be heard, my lord. So at this stage, interlocutory application is not necessary as the main petition is ready for hearing. So, my lord, can
Are
you?
you agreeable to the proposition that the main petition can be heard?
No, my lord, it was not listed, but we filed our affidavit. They took time to file it.
Now, Mr. Fukan is saying that the pleadings have been complete.
Pleading complete now.
Now, if you are agreeing, then we can fix the matter
Pleading
for admission hearing
Yes, my lord.
Yes,
on the date fixed.
That may be.
fix, my lord.
What's up? It is submitted. I don't know exactly, that in the main writ petition, pleadings have been exchanged. First up, Sri Fukan, the learned counsel for the writ petitioner, K.K. Fukan, learned counsel for the writ petitioner has submitted that instead of considering the interim, considering the IA, comma, the writ petition itself can be heard. Full stop. Para. Considering the above, comma, while the IA is kept pending, comma, list the writ petition for admission hearing on
the written that my lord, early date, my lord. And
on
2 weeks, my lord.
on 14th, on 21st August.
My lord, court may be directed to the petitioner to refrain from taking certain documents unauthorizedly. I have annexed some documents at page 23. My lord, there is a WhatsApp message and they are
Against this charge has been framed, my lord, and
subordinate
that charge is
authority.
also suspended.
On 21st, interim order passed earlier, stands extended till the next date of listing. Okay, rest matters, we'll give dates. Review, who to review? Card. Review.
May I please, Your Lordship? I have filed this review petition matter.
For
for my lord, the petition, for review the order that the petitioner who was working since 1997, whose appointment was made against the, in pursuance of the approval of the joint secretary, my lord. And the affidavit filed by the respondent number 5 in the writ petition, where they have stated that in paragraph P, that they have terminated the petitioner, the district non-exempt mother teacher under the new education policy concerned district non-exempt non-sanctioned post during the service of all mother teacher, English teacher, LDA grade. The said policy has been terminated by the BTC authority on 6/4 dated 12/11/2004 in pursuance of the Executive Council resolution. And they have also received their salary. But here the petitioner, they have stated the petitioner also terminated, but no termination order was received by the petitioner. So thereby he was continuing from 2004 to till the disposal of this writ petition, and even today also he is working, my lord. In this connection, my lord, I am going to say that in Bilu Devi, the Guwahati High Court Honorable Division Bench passed an order that is where it was, this is the order, my lord, where in paragraph.
But we have considered this submission in paragraph 12.
But
We have considered this submission. Our submission, our observation may be erroneous. But how is it a case for review? Please read paragraph 12. Even assuming, fourth line.
But the no termination order was.
We have considered your submission.
Yes, my lord. But thing is that the India division bench order, if the termination order is not furnished to the officers.
We are not on that ground. We are on the ground of 10 years delay.
No, my lord.
Read paragraph 10. 12, paragraph 12, page 45.
The British authority put on record order dated 12/11/2004, whereby the decision was taken to terminate all appointees, including that the petitioners, which were made in post not sanctioned by the government of Assam. Even assuming for the argument's sake that the contention of the petitioner that a copy of the aforesaid order was not communicated to him. What introduced is that this court is long delay or more than a decade in appropriating this court. The said issue can also be examined by the communication dated 26/3/2018 issued by the Inspector of School BTC, wherein it has been stated that the petitioner has been discharging his service in the school on honorary basis. It is settled law that the provincialized school managing committee does not have any jurisdiction to make any substantial appointment, and the instant case the petitioner claims to have been appointed in the state school on 15/12/1997 as per an order by the Inspector of School Nalbari. However, as would transfer from the communication dated 12/11/2004, which is supported by the pleading that such posts were not sanctioned by the government of Assam. Under the fact and circumstance, this court is not inclined to accede to the prayer made in the petition, which is accordingly rejected. My contention is that the previous stated that they have served the terminated the petition, but the no termination order.
We have assumed, we have taken care of that, even assuming that it was not communicated. Then also, there are other grounds. You have just read.
No. Yes, but in this case, in this petition where it was clearly stated in.
Madam, you are arguing a review petition.
Yes, my lord.
You find out an error apparent on the face of it.
If the termination order was not furnished to the officer concerned by what the employee is concerned, how they will come to know that he was.
That is not the ground of dismissal of the writ petition. We have dismissed the writ petition on the grounds of delay and other materials on record. Show us an apparent error. Otherwise, we are not review court or the ambit of
the petitioner is
entertaining a review is very limited. It has to be within the four corners of law. Show us any grounds of review, apparent error. You can file an appeal. We are no one to advise. But if you file a review, you have to file if you make out a case for apparent error apparent on the face of it, where no extensive arguments will be required. That part we have taken care in paragraph 12. What are the grounds cited?
My ground is that the petitioner is working more than 25 years in the state court. In his service.
These are not grounds of reviews. These can be grounds of appeal. These are grounds on merits.
Considering his service, my lord. So he's working. So his salary may be. This court is also direct to pay the salary at least his salary.
Salary part we have made some observation. However, regarding payment, if he is actually serving, it's up to the state committee to arrange for payment after verifying. That much we have also said, paragraph 14.
Yes, my lord, but the managing committee is throughout his services, the managing committee has paying lump sum of rupees.
That is up to the managing committee. You file appropriate application for contempt if they have not. No case for review. Heard. Miss A. Bujar Bora, learned counsel for the petitioner, for the applicant who by means of this application has prayed for review of the order dated 13/5/2023 passed by this court in WPC 7878 of 2017. Miss, the learned counsel for the applicant has submitted that at no point of time any order of termination of service of the petitioner, of the applicant, was communicated to him, and therefore the order is required to be reviewed. Full stop. Para. Miss R.B. Bora, learned standing counsel, BTC, as well as Sri Ardhar, learned state counsel, has submitted that exercise of powers of review is limited only if an applicant is able to make out any grounds, an applicant is make out the grounds for such review. Full stop. It is submitted that unless an error apparent on the face of the records is made out, or it is able to be demonstrated that the findings arrived by this court are perverse to the materials and record, or any other sufficient grounds, a review would not be maintainable. Full stop. The principal submission made by the learned counsel for the applicant is on the aspect of communication of the order of termination of appointments. Full stop. This court has, however, noticed that in paragraph 12 of the judgment, the aforesaid aspect has been not only considered but also dealt with. Full stop. This court has also taken into consideration the materials the other materials, the contemporaneous materials, including the communication dated 26/3/2018, issued by the Inspector of Schools BTC. Full stop. The appointment of the petitioner in a provincial school by the school managing committee has also been taken into consideration. Full stop. Para. The exercise of review by a writ court is permissible as the powers under 226 is plenary in nature. Full stop. However, such review should be in the lines of those mentioned in section 114 of the CPC, read with order 47. Rule, is it? Rule silent, huh? The grounds provided are limited in nature, and a review court cannot exercise powers. A review cannot be filed, an appeal cannot be filed in the guise of a review. Full stop. The submissions made by the learned counsel for the applicant, as observed above, were dealt with, and this court cannot go into the merits of the decision taken. Full stop. In the case of so and so, Madhusudan, Madhusudan. In view of the above, review petition is dismissed.
Take the bless.
Madhusudan like this,